Good morning, good afternoon and good evening. A warm welcome to everyone joining us today for this online event on the occasion of the 30th anniversary of the Convention on Protection of Children and Cooperation in Respect of Intercountry Adoption, which was adopted in The Hague on the 29th of May 1993. An anniversary or a birthday is of course an occasion to celebrate. But not only. It is also an occasion to reflect on what has been achieved, the challenges faced, what has been learned and how to face the future. Today's event thus is not only a celebration but also an opportunity to reflect on the past, the reasons that prompted the negotiation of the Convention, in particular the prevention of illicit practices, but also to consider what the future may hold and how we can continue to ensure that if and when an intercountry adoption takes place, it is indeed in the best interests of the child and in respect of their fundamental rights. Over these 30 years, the 1993 Adoption Convention has continued to grow, and today 105 states are party to this core HCCH Convention. While this is a great achievement, the challenge is still to ensure that all states parties are able to implement and operate the Convention properly. So today we hope to get some views and ideas for this fundamental objective. After 30 years, it is clear that the panorama of intercountry adoptions has changed considerably. Not only has the principle of subsidiarity been implemented in many countries, which is a good thing as it is a key aspect of the Convention, the profile of children in need of adoption has also changed, and there has been a significant decrease in the number of intercountry adoptions. We have also seen an increasing need for further support and counseling for adoptees and their families. There may be less adoptions taking place, but the need for post-adoption services is not about to diminish, quite to the contrary. To discuss these questions and much more, we will have the pleasure of hearing from adoption experts through two different roundtables, one on learning from the past and one on looking to the future. However, in the field of adoption, it is also crucial to listen to those with real, lived experiences. We will therefore have the opportunity and pleasure to listen to a birth mother, an adoptive mother, and an adopted person. According to Professor Peter Selman, over 1 million persons have been adopted intercountry since the 1960s. The Convention might be 30 years old, but adopted persons under the Convention are mostly younger. We may therefore have to wait until the Convention reaches its next milestone, the 40th anniversary, to listen to more persons adopted under the Convention. In any case, I look forward to hearing the testimonies of those with real lived experience and to learn from them. Finally, I would like to thank the central authorities of Norway and France for their voluntary contributions that have made it possible to have interpretation in English, French and Spanish, and therefore has allowed us to reach a larger number of persons all around the world. Thank you very much indeed. I would also like to thank wholeheartedly all our panelists and speakers. I sincerely appreciate the time you have dedicated to making this event a reality. And so without further ado, I hope that this event provides us with an opportunity to engage, to exchange views and listen to new ideas, all to ensure that the Convention continues to provide the proper framework for intercountry adoption and that we can develop and strengthen good practices in inter-country adoption. Thank you.
Welcome to everyone to this online event on the 30th anniversary of the 93 Adoption Convention. Je souhaite la bienvenue à tout le monde à l'occasion du 30e anniversaire de la Convention de 1993 sur l'adoption internacional. Bienvenidos y bienvenidas a este evento con motivo del 30º aniversario del Convenio sobre la Adopción Internacional de 1993. My name is Laura Martinez Mora. I'm Secretary at the Permanent Bureau of the Hague Conference on Private International Law. Before starting today with this roundtable about learning from the past, I would like first to thank many persons, authorities and organizations who have helped us to organize this event. And in particular, I would like to thank all the persons with a life experience who have accepted to participate in this event, and also to many others who have also helped us to organize it. In this first roundtable about learning from the past, we will have the pleasure to count on the following experts that will be sharing with us their views and opinions. Nous allons avoir Madame Luce de Bellefeuille, experte indépendante en enfance internationale pour le ministère de la Santé et des Services sociaux du Québec, Canada. Le professeur Yves Denecher, professeur d'histoire contemporaine à l'Université d'Angers en France. Ms. Nirmali Pereira, a Senior Probation Officer at the Central Authority in Sri Lanka. Y finalmente la señora Carolina von Chacman Cabrales, que es abogada en Mejor Niñez, la Autoridad Central de Chile. You can find more information about all the bios of all the participants in the ACCH website. Nous allons maintenant commencer par une première question générale et pour cela, nous allons nous adresser au professeur Yves Denecher. Donc, professeur Yves Denecher, quelles sont les principales formes de pratiques illicites qui ont eu cours pendant les différents temps de l'adoption internationale? Depuis quand est-ce qu'on sait de ces pratiques illicites? Depuis quand elles sont-elles documentées, connues par les différents acteurs? Merci beaucoup.
Bonjour, merci pour l'invitation. Je vais peut-être commencer par présenter un peu les grands temps de l'adoption internationale et puis effectivement ensuite expliquer comment les pratiques illicites sont apparues, se sont développées et puis aussi ont été finalement très vite connues de tous les acteurs de l'adoption internationale. Alors on peut remonter pour cette adoption nationale contemporaine au lendemain de la Deuxième Guerre mondiale, où là il y a un certain nombre d'enfants qui sont nés de rencontres entre des soldats, des militaires qui ont fait la guerre et des femmes de pays occupés, libérés, et on pense évidemment à tout le continent européen en premier lieu. Et de ces rencontres forcées, il y a eu de belles histoires d'amour, mais il y a eu aussi des viols, de la prostitution, etc. Sont nés des enfants qui avaient beaucoup de mal à trouver leur place finalement dans la société dans laquelle ils naissaient. Et donc il y a des premiers mouvements d'adoption internationale d'enfants qui sont nés en Grèce, qui sont nés en Italie ou qui sont nés en France, et en Allemagne aussi, au lendemain de la Deuxième Guerre mondiale, quand l'Allemagne est occupée par les pays vainqueurs, et un certain nombre de ces enfants sont adoptés et constituent ce qu'on peut appeler le premier flux de l'adoption internationale. Et puis ensuite, le développement de l'adoption internationale a beaucoup à voir avec les guerres. Ensuite, on peut évoquer la guerre de Corée de 1950-1953. Là aussi, de nombreux enfants naissent de pères GIs américains et de mères sud-coréennes. Et là, c'est Harry Holt, un Américain, qui va développer véritablement le premier grand flux d'adoption internationale organisé avec l'envoi aux États-Unis, en Europe aussi, d'enfants sud-coréens. Et puis arrivent ensuite les guerres du Vietnam, qui vont être autant d'étapes dans le développement de cette adoption internationale. Alors, dès les débuts de l'adoption internationale, il y a une prise de conscience de la part d'un certain nombre d'acteurs que cette adoption internationale est propice ou peut développer des pratiques illicites et des irrégularités et être source de dérives. Et dès les années 50, fin des années 50, début des années 60, on a un certain nombre de réflexions, on a un certain nombre de réunions entre des États, entre des organisations internationales, je pense notamment au Service social international, qui mettent sur la table cette question de dérive ou de pratique illicite. Et de quoi parle-t-on quand on parle de pratiques illicites? On parle d'un spectre très très large qui va des irrégularités et des, j'ai envie de dire, petits détournements de règlements, de législation, etc. Sur l'autre côté du spectre, on va jusqu'au crime, c'est-à-dire des achats d'enfants, des vols d'enfants. Et entre les deux, on a toute une gamme de délits très importants, très nombreux, très variés. On peut penser aux faux documents administratifs, aux fausses déclarations de naissance, à l'usage de ces faux documents qui vont ensuite, évidemment, impliquer des adoptions internationales qui sont entachées de pratiques illicites. Alors, cette grande variété ne veut pas dire évidemment que toutes les adoptions internationales sont touchées par ces irrégularités et par ces pratiques illicites, mais il est vrai qu'on est dans un système qui, d'une certaine manière, permet ce genre de dérive parce que il n'y a pas de cadre juridique bien posé, ce que fera la Convention de La Haye à partir de 1993, mais les tentatives antérieures de poser un certain nombre de cadres juridiques, etc., ont fait long feu et n'ont pas donné grand-chose. Alors, bien avant la Convention de La Haye, bien avant 1993, eh bien, les acteurs de l'adoption internationale se rendent compte qu'il y a des dérives, ils les dénoncent, que ce soit les diplomates qui sont en poste dans les pays, que ce soit des agences d'adoption ou des organismes agréés pour l'adoption, si je parle pour la France, qui signalent qu'il y a un certain nombre de choses qui ne vont pas, qui ne se font pas, mais aussi des parents adoptants, mais aussi ce qu'on appellerait aujourd'hui des lanceurs d'alerte, et qui évidemment dans les années 60 et 70 n'étaient pas appelés de cette manière-là, mais qui vont tirer des sonnettes d'alarme vis-à-vis des pratiques illicites dans l'adoption internationale. Donc voilà ce qu'on peut dire en quelques minutes pour brosser, si vous voulez, l'historique et les grands temps de l'adoption internationale en le reliant à cette question des pratiques illicites.
Merci beaucoup pour cette explication si claire et qui nous donne vraiment quelle est la situation avant la convention, comment ça s'est passé, qu'est-ce qui est arrivé au fil des temps pour l'adoption internationale. Ahora vamos a pasar a la señora Carolina Fonchacarman Cabrales y por favor, Carolina, ¿nos podrías explicar cuál es la situación de la adopción internacional en Chile antes de que Chile decidiese ser parte de este convenio? ¿Cómo y cuándo se fueron regretablemente desarrollando estas prácticas ilícitas? Muchas gracias.
Buenos días. Bueno, la verdad es que esta situación ha sido conocida con posterioridad. Hemos sabido que esta situación se inició en nuestro país aproximadamente en los años 50, 60, y podemos señalar que básicamente al amparo de la falta de legislación que había en la época, pues si bien nuestro país comenzó a regular la adopción en el año 1934, solamente incluyó figuras referidas a la adopción nacional, pero no se reguló ninguna modalidad de adopción internacional hasta el año 1988. Entonces, durante todo el periodo anterior, hemos visto que comenzó en el país una situación de búsqueda de niños y niñas muy pequeños, lactantes en su gran mayoría, para su entrega a familias que querían adoptar, tanto residentes en Chile como residentes en el extranjero. Y por los testimonios que hemos ido conociendo, esta situación comenzó a regularizarse a través de autorizaciones que daban normalmente las madres biológicas de los niños ante notarios públicos o ante tribunales de menores de la época. Sin embargo, la situación que nosotros podemos señalar que se configuró con un verdadero tráfico de niños, aunque nuestro país no tipifica el tráfico hasta la actualidad, tenía su origen en que se engañaba normalmente a mujeres de escasos recursos, de una situación socioeconómica bastante deprivada, y le presentaban la salida del país de sus hijos o la adopción de ellos en forma interna como la única alternativa de solución a la problemática que presentaban. Podía ser que mediaran entrega de recursos, pero normalmente eran engaños, o se incurría francamente en delitos, como por ejemplo madres de muy escasos recursos que tenían sus hijos en hospitales públicos y posteriormente se les decía, eran anestesiadas durante el parto y luego se les decía que su hijo había fallecido, ¿ya? Y el niño era entregado efectivamente en adopción o era confiado al cuidado a familias, muchas de ellas residentes en el extranjero, y se autorizaba la salida del país o se recurría a distintas figuras. Seguramente en estos casos entendemos que eran inscritos civilmente como hijos de quienes iban a adoptar o iban a aparecer como sus padres, ¿ya? Esas son las figuras de las cuales hemos tomado conocimiento. También se realizaban en suplantaciones de parto, o sea, figuras en que ingresaban a clínicas que eran las mismas siempre, tanto la madre biológica como la supuesta madre, y la clínica extendía el comprobante parto a nombre de la supuesta madre. Todas esas situaciones hemos tomado conocimiento con posterioridad, como les decía, básicamente al amparo de la falta de legislación que había en la época, y esta situación se mantuvo bastante durante el tiempo, porque si bien Chile ratificó la Convención sobre los Derechos del Niño en el año 1990, convención que ya estableció la importancia de que las adopciones se realizaran con pleno respeto a los derechos de los niños y su familia, y se estableció la subsidiariedad de la adopción internacional, esta figura no tenía su correlato en la legislación interna chilena, que no continuaba sin regular la adopción, en especial la adopción internacional, ¿ya? Y bueno, esta figura se mantuvo en el tiempo. Cada vez más se organizaron redes de intermediarios particulares que operaban en esta figura, especialmente abogados, médicos, asistentes sociales, por la investigación que se está realizando en Chile. Y es así como se ha tomado conocimiento de que salieron de nuestro país muchos niños en estas circunstancias. En el país solamente se comenzó a regular una primera modalidad de adopción internacional en el año 1988, en que por primera vez se le dio funciones solamente en materia de salida del país de niños con fines de adopción en el extranjero al Servicio Nacional de Menores, que es el antecesor legal del actual Servicio de Protección Especializada a la Niñez y Adolescencia, que es la autoridad central para los efectos del Convenio de La Haya, ¿ya? Y es así como empezamos a intervenir en este sistema, y ahí fue posible apreciar cuál era la magnitud de esta situación, sobre todo salida del país de niños, ¿ya? Por darles una referencia, el primer año de vigencia de esta ley, el servicio recibió 1020 solicitudes de salida del país de niños, y el 95% eran referidas a lactantes. En ese tiempo ya existía una demanda incipiente de familias residentes en Chile interesadas en adoptar, pero no existía el procedimiento legal que permitiera darles prioridad, y es así como continuaban saliendo del país niños bajo estas figuras, en que por supuesto que se vulneraban sus derechos y también los de su familia de origen, en especial sus madres. Esas fue básicamente las figuras que hemos conocido en la actualidad a raíz de las investigaciones que se han dado en el país y que en estos momentos están en su curso, y sin perjuicio de haberse regulado, de haber sido muy importante la entrada en vigor en Chile de la ley actualmente vigente en materia de adopción, la ley 19.620 en el año 1999, junto con la entrada en vigencia en Chile del Convenio de La Haya, también en el año 1999, y es así como pudimos apreciar cómo fue disminuyendo estas figuras en el tiempo hasta que la adopción internacional pudo centrarse en su verdadero sentido, que es constituir una alternativa para aquellos niños que no pueden encontrar una familia en su país de origen.
Muchísimas gracias, Carolina, por toda esta explicación tan clara y detallada, que creo que nos ayuda mucho mejor a comprender cuál era la situación en la época y cómo ha ido evolucionando. Bueno, ahora vamos a pasar a otra pregunta. Now we are going to pass to Ms. Nirmali Pereira from the Sri Lanka Central Authority. Good morning, Ms. Nirmali. We would like to know a bit more about the situation in Sri Lanka because regrettably illicit practices also took part in Sri Lanka in the past in relation to inter-country adoption. So we would like to know from you if you can explain how this happened, why these illicit practices took place, and what is the situation today, what has been changing. Thank you.
Thank you, Ms. Laura, for the question. It's actually a very timely, important question for the Sri Lankan Central Authority. Actually, when we look at the background situation in 1970s and 80s, that we have observed that many children have been placed for intercountry adoption in those days. Because that when we look at the social, economic, and cultural background of Sri Lanka, the nature of local adoption and the push factors led to the rise the foreign adoption in 1970s and 80s. Mainly, we have observed that that situation in that country, especially the social background, that there were the childless, the domestic applicants, but due to various reasons, the social, sometimes they think that the adoption of a child is like a social stigma, because they really didn't want to reveal that the child is adopted. And also, in addition to that, we have noticed that the people, they have changed their place of residence from one province to another province, and also that sometimes they were pretending as they are pregnant and try to adopt the children very secret way. They actually did not reveal the child, even that the child is an adopted child. So this was the situation at that time. Then the more children has been placed in foreign adoption. So that was the situation at that time. And in addition to that, we have noticed that at that time, the law, which is related to intercountry adoption and the domestic law, there was a room for encouraging the intercountry adoption process up to 1992. The law has not been amended. Then it was amended in 1992. Only the children who were in the institutional care, that means in the children's homes, can be allocated for foreign adoption. It was one of the new provision which were included in the new law. And also the penal code has been amended several times, and also these amendments took into account the illicit practices in Sri Lanka. Therefore, I think because of these the law amendments, the authorities have taken steps to reduce the number of children placed in foreign adoption. So you can see the statistics which we have already submitted, that the gradually, starting from 1991 up to 2022, the number of children placed for intercountry adoption has been remarkably reduced, while the domestic adoption, the number is increased. So this is, I think thereafter we signed the Hague Convention in 1993. So then I think it was I think big achievement from Sri Lankan side, and as well as the other as a country of origin, and as well as the country of receiving. All countries which are signatories to the Hague Convention started to adhere to the provisions of this domestic law and intercountry adoption law. Therefore, I think we were able to reduce the number of children given for foreign adoption, and also increase the domestic adoption process. So I think this is when we look at the Sri Lankan background, now the most of the prospective adoptive parents, they have come forward to adopt the children, not like those days. Because now people are, I would say that they are very educated and they are now thinking about the rights of the children, and they think that they need to have a complete family. Therefore, now they have come forward to adopt children. So then that we place children for local adoptions now.
Okay, thank you very much, Ms. Nirmali, for all this explanation, where it's very interesting to see as well how the principle of subsidiarity has been implemented in Sri Lanka as well with the assistance of the convention. And now we are going to turn to another country and we will go to Canada. Pour cela, nous comptons avec la participation de Madame Luce de Bellefeuille. Alors, Madame Luce de Bellefeuille, la loi de mise en application de la Convention de la Haye de 1993 est entrée en vigueur au Québec en 2006. Est-ce que vous pourriez, s'il vous plaît, nous expliquer quels changements cette loi a entraîné en matière d'adoption internationale et aussi si vous avez quelques exemples concrets dans la loi de comment elle a été mise en œuvre pour essayer de prévenir les pratiques illicites. Merci beaucoup.
Alors, bonjour Laura, bonjour à tout le monde. Certainement qu'on a eu effectivement des changements majeurs, des bouleversements au moment de la mise en application de la Convention de la Haye de 93. Les bouleversements au niveau juridique, au niveau de la gouvernance, au niveau des relations multidisciplinaires. On a dû faire face à des changements en profondeur de nos procédures, de nos façons d'exercer nos rôles respectifs. Et quand je dis nos rôles, je parle de toute la communauté des gens impliqués en adoption internationale. Et également, tous nos outils de gestion ont dû être revus, créés dans certains cas. Alors, cette réforme s'est échelonnée sur 18 mois, période durant laquelle on a connu des frustrations, des résistances, mais malgré tout, un changement de mentalité s'est opéré peu à peu. Par exemple, de changement, les développements d'une vision sur les droits de l'enfant ont été mis en place plutôt qu'uniquement une vision basée sur les besoins des parents. Développement d'une vision de partenariat plutôt qu'une compétition entre acteurs. Des pratiques qui sont devenues uniformes, équitables plutôt que disparates. Une vision sociale de l'adoption s'est développée plutôt qu'une vision strictement individuelle. Une attitude de coopération avec les pays d'origine plutôt qu'une attitude de requérant. Alors, il y a une ouverture aussi à des relations entre les États d'accueil. Alors, en gros, c'est comme si une synergie s'était mise en place. Cette mobilisation envers la protection des droits des enfants a été finalement entretenue grâce à la mise sur pied d'un comité de concertation. Un comité multidisciplinaire qui réunissait, je crois qu'on était 17 représentants de toutes les communautés, des ordres professionnels, des établissements, les organismes, l'association de parents, les associations d'enfants adoptés qui se sont ajoutées avec le temps. Alors, ce comité-là, son rôle, c'est d'assurer l'application des règles, des échanges d'expertise, la poursuite des réflexions pour améliorer les pratiques. Grâce à ce comité-là, il y a la formation des parents qui ont été mis sur pied, la formation des professionnels, tout un travail aussi de suivi pour la mise en place des recherches des origines et des retrouvailles pour les enfants, les adultes, devenus adultes dans le fond. Du point de vue opérationnel, le secrétariat est devenu en 2016 la seule porte d'entrée pour entreprendre une démarche d'adoption, sauf exception pour les adoptions qui pourraient être présentées pour des circonstances exceptionnelles qu'on va voir plus tard. Toutes les adoptions doivent être réalisées à partir de cette date-là avec le soutien d'un organisme agréé, dûment agréé par le ministre de la Santé et des Services sociaux. Donc, après vérification des obligations légales essentielles, le secrétariat attribue un numéro de dossier et émet l'autorisation aux adoptants de procéder à des évaluations psychosociales. C'est un autre élément nouveau de la mise en application. Aussi, l'entrée en vigueur de la loi a aboli les agréments permanents qui existaient pour certains organismes. Et dès lors, les organismes agréés ont dû se soumettre à des règles de reddition de comptes beaucoup plus strictes. Un agrément par pays, par exemple. Un rapport annuel d'activité suivi de recommandations s'il y a lieu et mention au dossier qui font partie de l'évaluation aux 3 ans pour le renouvellement de chaque agrément. On a rajouté à ça une limite d'ouverture de dossier dans le cas d'un nouveau pays pour un organisme. Un comité d'agrément est également mis en place. Ce comité d'agrément est dédié à l'analyse en profondeur des demandes, soit pour des nouveaux, soit pour des renouvellements d'agrément. Et tout ce processus qui est présenté au comité d'agrément, l'évaluation se prépare sur une période de 6 mois. Et plus c'est nécessaire. Le temps de faire l'analyse de tous les documents qui sont demandés et présentés par l'organisme, de faire des vérifications, d'aller faire une mission si le besoin se fait sentir. Alors, et à la fin, après l'étude avec le comité, une recommandation est soumise au ministre avec renouvellement avec ou sans condition, un non-renouvellement aussi peut être fait et c'est accompagné des raisons de la décision. Je me permets ici d'ajouter brièvement que nous est arrivé plusieurs fois de retirer ou de refuser un agrément. Ce qui est nouveau aussi dans la loi, c'est que le ministre a le pouvoir d'inspection et d'enquête, entre autres pour exercices illicites d'activités d'adoption sans agrément, avec des dispositions pénales qui n'existaient pas en cas de contravention, des amendes qui peuvent varier entre 10 000 et 200 000 selon l'article, la contravention observée. Un autre effet de la loi de 2006, c'est que le secrétariat devient responsable des recherches et des retrouvailles en matière d'adoption internationale, donc dépositaire de tous les dossiers d'adoption internationale qui étaient répartis un peu partout chez dans des autorités compétentes comme chez des directeurs de protection de la jeunesse ou auprès des organismes. Finalement, pour répondre aux demandes d'adoption sans organisme qui sont prévues par un arrêté ministériel, comme les adoptions intrafamiliales ou pour circonstances exceptionnelles, un 3e comité est formé dédié uniquement à l'analyse de ces types de demandes. Encore une fois, c'est la carte, c'est notre... comment je dirais, dans pas notre ADN, mais notre façon de fonctionner, c'est que les décisions ne sont pas prises seulement par une personne. Ce comité de circonstances-là est formé de personnes de l'équipe avec des responsabilités ou des expertises différentes. Alors, de cette façon-là, les dossiers qui sont très délicats dans ces cas de circonstances exceptionnelles font aussi objet d'analyse en profondeur parce que ce sont des dossiers délicats où il y a beaucoup plus de pression qui viennent de l'extérieur. En terminant, je voudrais juste vous dire que toutes les mesures qui sont mises en place par le secrétariat ne garantiront jamais l'absence totale et absolue des dérives et des pratiques irrégulières. Mais à mon avis, ces mesures-là, dites de vigilance pour nous, ajoutées au guide de bonnes pratiques en adoption internationale du Bureau permanent de la Haye, permettent de prévenir, à mon avis, et enrayer autant que faire se peut, les situations à risque de dérapage. Merci.
Ahora vamos a pasar de nuevo a Carolina. Entonces nos gustaría un poco saber de forma resumida, porque el tiempo va pasando rápido y tenemos más mesas detrás. Entonces, ¿qué es lo que se hizo o qué es lo que se está haciendo en Chile para poder remediar a los abusos del pasado y en qué ha ayudado, si es que ha ayudado la Convención de 1993? Muchas gracias.
Well, there is a lot yet still be done, as has already been said. our country lacked legislation, as I said before, and as a result of individuals and some NGOs' involvement, it was possible to change the situation, but that only really happened back in '88 when Chile regulated the first mode of inter-country adoption. And a legal channel was created through which children could be taken out of the country. But there was still some irregular adoptions, such as mothers being tricked into giving up their child, or the child being acquired for a payment. So there were lots of private intermediaries involved, lawyers, social services, some representatives of religious organizations. They did so as entities that wished to do something good for the child, but they weren't abiding by the rules. And back in '89, these things were still going on, but in 1990, we became party to the convention. But unfortunately, we had no internal legislation, which made things quite difficult. So the previous central organization that safeguarded children took over an important role in safeguarding children who were taken out of the country. The service also created a national adoption program for adults resident in Chile who wished to legally adopt a child, but things again changed in '99 when the current adoption law was passed. And it was only possible for adoption programs to be conducted through the specialist national department for that, and it had to be done through an accredited body. And that provided for services to the biological mother, the child to be adopted, and the prospective adoptive parents. And then in '99, we subscribed to the Hague Convention and subscribed to all the protections it provides. And as a result, we were able to work with the states party to the convention. And as a result of which, we've been able to provide an alternative for children who cannot be adopted within Chile to be adopted and be taken to other countries. We also provide a new service to biological parents who wish to trace their children who were adopted, perhaps in an irregular fashion. They can find information about those children, and that has also given rise to some legal actions. In 2017, a body was created to investigate this type of adoptions between 1973 and 2017. And state agents were involved in these investigations. But unfortunately, things still continue to happen. Then we appointed a minister to continue investigating, and continues to do so today, helped by the creation of private organizations who bring together the biological parents and the adoptees who are trying to trace their origins. And a search can be conducted to trace the adoptees' origins. And that is done through government departments, through the courts. And we also have investigative committee since 2018, which collects testimony and brings together any public bodies that might have relevant information. And now there are a number of cases open. Obviously, it's difficult because at the time when all of this happened, there were very few powers in place for investigations to take place. And really, the victims of these illegal adoptions wish to, more than anything, get justice. And really, that's the explanation of the situation in Chile. Thank you very much, Carolina. It's always very interesting to hear the perspective of the countries where children are adopted into, but it's also important to understand what the associations are doing to help the birth parents to trace their children. We'll now go back to Mr. Benacher. And we have a question for Yves. What have the attitudes and positions of those involved in adoption been with regards to illicit practices, and what link is there between that and the search for one's origins? Well, in order to very quickly answer your question, but at the same time, I'd like to make it clear that many of those involved in inter-country adoptions were aware of the existence and the risk of illicit practices back in the 60s, 70s, and the 80s. Many bodies drew attention to what was going on within the field of inter-country adoption, things that weren't in line with the laws of the recipient or the country of origin, and many practices that didn't safeguard the rights of the child. But logic will have it. The prospective adoptive parents want to adopt, the intermediaries have their own agendas, and the regulator does what it can to regulate, but sometimes they just can't achieve their aims, and there are sometimes abuses that are very often referred to as being one-off or isolated cases. But not all, well, I mean, I think probably everyone was aware of what was happening, because there would have been denouncements of prospective adoptive parents, of intermediaries and states, and sometimes diplomats and country representatives would denounce this when they came across cases of illegal adoption. But there was always a tendency to try and diminish the importance of these risks, because there were vested interests involved, and perhaps the state hasn't really reacted in the best way it could. I'm saying, you know, government states didn't really react as well as they could have done. And with regards these illicit practices that are uncovered when people are trying to trace their origins, well, this has been referred to by previous speakers. When people are trying to trace their origins, sometimes they uncover the fact that they were victims of illicit adoption and irregular practices. And for some, in inter-country adoptions, there are now associations involved. So things are changing. The issue of illicit practices is sort of like a brick wall that sometimes in inter-country adoptions one runs into, and behind those brick walls are the adoptees, and there are countries that really are lagging behind in terms of their reaction to this situation. How can we help people to trace their origins when they have been victim of irregular adoptions? Well, we can accompany them, we can try to help them. But saying that there were illicit practices in inter-country adoptions in the past due to the high demand for children, we have to acknowledge that these abuses existed. If we look back, we'll see that in coming years, there will be large numbers of people who wish to trace their origins, and we will uncover perhaps greater numbers of illicit practices. So now we have to consider how we can guarantee that rights are upheld, because there may have been mistakes made. DNA is going to play a very important role in all of this, but we need to see how we can mitigate the risk of on the basis of people's family histories, creating situations where maybe a woman is asking questions about an adoption that took place 20, 30 years ago. That decision was taken 30 years ago, and even today is something that she finds very difficult to get her head around. That generates many issues that we really have to deal with. I think it is good that we recognize that these problems exist and try to find ways to resolve them. In summary, money always causes problems, sometimes big problems.
Let's now move to Madame Pereira again, and we would like to know a bit more on how Sri Lanka supports the search for origins. Is there a specific program to do that? Is there some specific support, and especially if when the adoptees search and find illicit practices, which kind of support? And as well, is it possible to take any legal action in the case that illicit practices are discovered? If you could share a bit what has happened in Sri Lanka, that will be really good. Thank you.
Yes, thank you for the question. And we have received so many requests of search for origin from the adoptees from Sri Lanka. So sometimes the adoptees directly submit their request to the department, sometimes through their respective government central authority or through other agencies. Recently, that we have received the search for origin request through the Sri Lanka Red Cross, like that. Some of these INGOs and NGOs are also submitted the request of the adoptees because of the various reasons. Sometimes there are language barriers that they don't understand how to lodge their application. There is no particular format introduced for that, so they don't know how to reach the central authority in Sri Lanka. So therefore, they had to reach to the department through their own personnels. So this is one of the areas that we have discovered that the problems faced by the adoptees. However, some of the countries, they have developed their own systems to lodge the application of the adoptees. So then after receiving the applications, the request of the adoptees, we review their application and try to search the previous files of the adoptees. Unfortunately, this adoption had taken place in many decades before. Therefore, most of the documents are in decayed condition, but some of the documents are still remain in the department. So we search those files. But some of the adoptees, we have observed that they do not submit the sufficient information. So some of them, they do not have any legal document to prove their adoption, no adoption certificate, no birth certificate, nothing. So then we face lots of problems that how to help the adoptees. some adoptees, they have their documents with them, but some of them provided sufficient information, some are not. However, after receiving the documents, we search our document. We peruse all the previous documents, and also that we have to check the hospital where they born, and also the children's homes there where they have been resided at the time of adoption, and also the several institutions. We have to talk with them, and also with the courts also. It's time consuming anyway. So after finding this basic information through our officials working at the divisional level, we reach the family if it is possible to find the parents, so get the information of the biological family. We reach the family, and that we have trained our officers how to work with the family very secret way and not harming them any further, because some of the mothers that they don't want to reveal anything about their previous adoption. That biological family didn't want to meet the child, because we have come across the cases like that. Some biological mothers, they married once again, and they are leading a good family life, so they don't want to reveal anything about this adoption, and they say, no, I don't want to see the child anymore. So we have come across the cases like that. So then, however, we inform the real situation to the country of the applicant and the adoptee, and as well as the adoptee. So in meanwhile, we have found out some of the suspicious cases as well. The acting mothers and forgery documents, we have found it. So then actually the central authority in Switzerland once submitted the document of the request of the adoptee, and we tried to trace the biological family of the child. Then we realized that it's illicit practices had happened with regard to that case. Then we informed the real situation to the Switzerland Central Authority. Then the Switzerland Central Authority requested us to take the legal action against this particular case. But the problem was that at that time we requested the Sri Lanka Police, the Inspector General of Sri Lanka Police, to take to do an investigation with regard to that case and take legal actions to the case. But the problem there was Inspector General of Police has informed us that according to the section 456 of the Code of Criminal Procedure Act number 15 of 1979, the rights of file a case has been barred. So it has been reported that taking further legal action in this regard is futile. So under this situation, it is not possible to take legal action for the decade-old cases. It's very clearly answered by the Sri Lanka Police to not the difficulties that they are facing when taking action against the decade-old cases. However, the present situation, the penal code has been amended several times in Sri Lanka. So the amendments took into account the illicit practices and as well as the trafficking of children cases. So the current cases that we can address the issues of these cases by this penal code, and also the law is tightened now. Therefore, we will be able to find solution, take legal action to those cases. And also the adoption ordinance is being amended now in Sri Lanka. So we have already decided to include the section about this adoptees search of origin part also, because there is no legal coverage for the central authority to intervene the search for origin matters legally. And considering this situation, that actually the central authority in Switzerland requested us to establish a proper system to trace the biological parents of these adoptees. Then what we did was the Back to Roots, the organization negotiated. Then there had been several discussions with them, and still the discussions are going on to establish the particular the program to search the biological parents of these adoptees. But the problem is it is only for the adoptees of the Switzerland, but not for the other countries. Therefore, I think we should have to have a common system how we should assist these applicants, because when it comes to the local scenario, it's very that we have our own officers, but the adoptees they do not trust either the country of origin and neither nor the country of receiving. So they don't want they want the independent body to intervene their request. So we have to discuss this further and establish the proper system to address the issues of adoptees.
Thank you very much, Ms. Nirmali, for all this explanation and as well for showing the importance of cooperation between different states, but as well in the state, I think is one of the key pillars of the 93 Adoption Convention.
To go back to Mrs. Luz de Bellefeuille, we wondered whether you could very briefly, because we've only got 50 minutes left for the rest of this round table, and we'd like to hear everyone else's wishes for the future, which are still to come. We'd like to know why in 2006 you actually first saw, you were able to foresee measures to respond to requests for looking for people's ancestors, socio-biological ancestors and reunions. Yes, in Quebec, a group of adoptees, people that have been adopted in Quebec through national adoption processes, were actually founded in 83, a movement that was called Reunions Movement, which was to basically support adults that had been adopted to find their parents, mother or father or both. And we were able to, through this reunions movement, what it did was it actually raised awareness amongst the general public in our country of the actual fundamental need for absolutely any individual to know their life history. You know, that was actually inspired by a television production that was basically narrating people's searches for their parents or vice versa. So the key feature here was the reunions. And so basically there was a young woman or young women and men that are adopted, and finally at the end they managed to find their parents. And so, as I say, the movement was able to raise awareness in people. And so, you know, you've got people's fears, their despairs, these feelings that they go through, and then the joy of being reunited with their parents or vice versa. And so we were able, at the moment, we are working on draft legislation, because the Secretariat's only actually received a couple of requests a year for origin searches. And so in our discussions about, you know, children's rights within, you know, inter-country adoption and the relevant areas of the Hague Convention, you know, we have managed for Quebecois children that have been adopted internationally will be able to have this same facility so as to be able to request this origin search. We want to basically bear in mind all of the different needs that they have as regards knowing the names of their birth parents. And this obviously, you know, internationally speaking, this could basically awaken in people the same emotions, you know, of anxiety, of embarrassment, of shame, you know, reticence, anger, feeling rejected, abandoned, etc. So it seemed that we would need a new law that would be accompanied by, you know, different overtures towards what's been done elsewhere. And so this law basically obliges the Secretariat to basically keep all of the inter-country adoption dossiers that are held by our different partners, and to work on numerizing them all in an archive, a central archive. so as to be able to establish bridges with those people who intervene at different parts of the process, so as to be able to put together a real collaborative end piece of work, so as to be able to correctly or adequately rather face this new phenomenon that's before us. And so we really need to do this together with the management of protection of young people, and we have to be able to respond to these requests of origin searches when it comes to national adoption and inter-country adoption. But we have to really make sure that these are framed around the people who make the requests, and we have to also make sure that they all go through the Directorate of Protection of Young People. And so we could see that having this put into law has borne fruits, and we've seen in our statistics that the amount of origin requests I'd mentioned previously, it had only been 2 per year, it's gone up quite a lot. So the statistics show that there was 17 requests of this nature made in 2013 and 161 in 2021. So I'd like to just finish up with what my colleague Eve said. We can see there's different variables that that basically come into play here, and that are often come in basically are things that might seem contrary, the one thing to the other, you know, so we have to treat these things with a lot of sensibility, and we have to be very delicate in our treatment of them. Thank you so much for having explained to us how you go about these things in Quebec.
We don't have much time left for this roundtable, but I wanted to at least address 2 things. One question that was put by the public.
So, Professor Yves Denecher, we had a question from the public just before or ahead of this online event, and it's about the costs. We wanted to know whether the past had actually taught us that having to ask people, or people who were used to having to pay lots of money to adopt children, comes into conflict with this idea that adoption should be a protective mechanism that's anchored solely on the child. Well, we know that the past is never a learning instrument, and we know that all round from what we see in human existence as a whole. However, the mistakes of the past, if you like, have been due to the fact that there have been a lot of different risk factors, and without a doubt, the main risk factor, which is the illicit practice of inter-country adoption, or within inter-country adoption illicit practices. We've seen this, we've seen proof of the fact that these practices are now documented from very early on, you know, we're talking about before the 1960s, whether this be International Social Services or the Council of Europe. We've always asked ourselves the question about where money should come into inter-country adoption. In France, a couple, a family, anyone who adopts through the States, well, that's the process is free. We put in place a protective mechanism for that child, and we find them a family. And it's absolutely cost-free for the people that are going to receive and welcome that child. That's on a national letter. That's on a national level. 1960s, 70s, 80s, inter-country adoption, we can see that there's elements that say, look, this costs X amount. A child from this background costs this, a child from the other background or from this country costs that. So I'm in agreement with the idea that's behind all this. Why? Well, why is there money? And from the very starting point that there's money involved, can that really lead us to the one protective mechanism anchored solely on the child? And so we have and before and after the Hague Convention, because we've got all of the practices that are not illicit. They're not 100% clean today. We're still very far from that, but there's still a lot of different complexities and nuances that we have to sort of navigate our way through when we talk about pre and post Hague Convention. Thank you so much for this very clear and very open response from yourself, and we think that's going to really provoke a lot of reactions. So just to finish off, we know that there are some questions that we had to just leave untouched upon because we don't have any time left. However, we'd like to hear from each panelist what their actual desire, recommendation, idea would be as regards what you would recommend for the future regarding inter-country adoption. So we spoke about this with Mrs. Luz de Bellefeuille, the Overseas Adoption Agencies, or inter-country adoption agencies, and what were the different mechanisms and the mistakes of the past, the mechanisms would be put in place to prevent them. And then we would also going to focus on listening to what the other round tables are going to explain to us and what's going to come out of those. So I think that we're now going to move on to this idea of one specific wish, desire, recommendation for the future. Who would like to kick us off?
Who would like to go with this recommendation for the future? Okay, Professor Denechère.
Well, yes, I can basically grasp this because I'm a historian, but we've not done a great job about grasping what's gone on in the past. Now you're asking us to project ourselves into the future. But as regards the notion of risks, if we look at ourselves, in the face, we're all actors within this, and we all have to face up to the errors of the past together. And I think we should really be able to derive from the mistakes of the past some lessons for the future, which we know still, we still have ahead of us a certain number of risks, which we should be able to organise ourselves around better, so as to be able to minimise them, and so as to be able to really come up with a protective mechanism. Thank you so much.
Okay, Ms. Nirmali, maybe?
Yes, with regard to this accredited bodies, actual role of the accredited bodies, that sometimes we have realized that the Sri Lankan applicants living in other countries, they have requested us to give the correct information about the central authorities and the accredited body to whom that they should meet with, whether it's a government central authority or the accredited body. There's no particular instruction, the correct instruction for the applicants living in other countries, especially the Sri Lanka, because some of them have gone to the accredited bodies and some of them go to the central authority. So the charges involved in this. So there should be a correct guideline for them to how to choose the accredited body or the central authority correctly. Because we are not in a position to advise them to choose the central authority or the accredited body in the country. Okay. So it's up to applicant to decide to whom that they should meet and go ahead with the process. So then my main concern is to discuss with all the central authorities and establish the proper mechanism and guideline for the applicants to enable them to choose the correct path. Thank you.
Thank you very much, Ms. Nirmali. Carolina? Luz?
Carolina, I don't know if you have some sort of recommendation or desire as regards all of your own experience on the matter, for the future, recommendation for the future regarding inter-country adoption. just in general terms, even where we're moving towards, some sort of desire or recommendation you'd like to express so as to finish up. Sorry. I don't know if I skipped Luke. Yes, you can speak. I think that we have to be very, very conscious of the fact that our focus should always be the child. You know, we have to centre on the family, and adoption could be a tool for that, but we need to centre on the right to an identity and how do we respect this right, and we have to obviously work in the best interests of the child as always. So our focus is how, at least in Chile, we can actually help support people who were victims of this situation of child trafficking and illicit practices in this whole time frame within which there was no existing legislation. How can we support those people? Over and above looking for the people responsible, these people want to find out about their origins and be reunited with their families. And so I think that we've said that the Hague Convention's obviously found its real essence, which is people who can't be adopted within the country, usually older children that have gone through a lot of difficulties. We want to make sure that they have post-adoptive accompaniment, and we want to make sure that this really is emphasised in the Hague Convention, how we can actually support families of origin and adoptive families when we're talking about inter-country adoption, and how we can enhance the origins search in our country. And we are actually wanting to open up a motion for voluntary post-contact for those origin family, you know, especially with those older children that know their own story, that know who their families are, and we know that we have challenges ahead. Thank you so much, Carolina. Luz? Yes, I just wanted to say that I agree with what's been said thus far, but when we're talking about this origin step, you know, having within the law the possibility to respond to these requests, and I think that, you know, we have to make sure that we're working on that with people who intervene in the matter in Quebec and with the central authorities in the different countries with which we work, because we know that there needs some sort of preparation and there has to be collaboration on the part of those countries of reception and those of origin. And so we really just do have to make sure that we're here, you know, obviously to celebrate 30 years of existence of the Hague Convention, a convention we're very attached to. We hold it very much in esteem, and the dynamic of the Hague Convention is to make sure that the convention comes to life, so to speak, in all of the decisions that are going to have an influence on the future of a child. And we have to not lose sight of the principles that the Hague Convention proposes. So I've said it once and I'll repeat it. I've had 13 years of experience working in inter-country adoptions, and I do really think that the Hague Convention is a reference point. It makes us go back to this essence time and time again and make sure that we apply it in decisions which are really heartbreaking often, but which are necessary. And so I just really do wish you all the best for the rest of our journey down this pathway towards protecting children within inter-country adoptions. Thank you so much, Luz. Thank you very much, Professor Dénicher, Nirmali, Carolina, for all of your ideas.
For all your ideas and sharing your views on the convention, on what we have learned from the past. There's a lot you have mentioned, like key problems being money, poverty, you said it at the beginning. Then we also saw some of the possible solutions that some countries are focusing or trying to give to, especially for adoptees. We have gone through the search for origins, which is extremely important now, trying as well not to have illicit practices there, to take that as well into consideration. I think we have spoken a lot about cooperation, the importance of cooperation between states. It is in the title of the convention. And let me finish by something that has also been said by many of you, that the center of all this is the child. And I think we should always have that in mind. And whenever we continue, it's very important to have this convention applied. It's just minimum standards, so we can do better, and we should do better. Thank you very much for your time. And now we are going to pass to the second round table. And for that, I will pass it to Ms. Karabo Osa, who is Director of the Center for Child Law in South Africa. And she's going to chair the second round table. Thank you very much to all of you.
Thank you very much, Laura. Good afternoon, good morning, good evening to everyone. Certainly, it's a very important day as we celebrate the 30th anniversary of the convention. Important time to reflect. And what I've picked up from the first panel is that everything that was said is very crucial. And as we'll see in this session that I'm sharing, the reflections of adoptees and birth mothers and adoptive parents will certainly highlight some of the issues that were mentioned, and also give us some ideas of the lived realities of people who are directly affected by adoptions, and how we can better the system for their protection, and more importantly, also focusing on people who were adopted prior to the convention, and the continued support they still need in various issues. So allow me to introduce our panelists for this afternoon. We have Ms. Claudia Gonzalez, who was adopted from Romania to Spain. We have Ms. Marie Marais, who was adopted from Mali to France. Both were adopted prior to the convention. Unfortunately, I think, as the Secretary General mentioned in his opening, people who were adopted under the convention are still a bit young, and it's not easy to get them to come and participate in this kind of forum. But hopefully in the next 10 years, as it was said, we would have them reflect about how maybe the convention has made a difference to how adoptions, intercountry adoptions take place. We also have Ms. Michaela Piscitelli, who is adoptive mother who adopted two boys who are now young men from Colombia. And lastly, we have a video which we will show a bit later from Ms. Janet Osorio, who is from Colombia, who is a birth mother who gave up her child for adoption. And she will share through the video the experience of the process, and also the challenges that came with that process. And later then, when she had an opportunity to start reunifying with her child who had asked to try and find her. Before we go to the video of Ms. Janet, I'm going to allow my panelists to just give us an opening from each of them, where they just tell us a little bit about themselves and their journey with the adoption system. And for this, I will start with Claudia.
Hello, thank you very much for inviting me to take place in this roundtable discussion. The first thing I'd like to say is that my experience is only really valid for those people who have information and legal documents, and who know the names of their birth parents and where they live. And it's really important to have that information as a starting point to begin your journey searching and researching your origins. With this information, well, you have to make sure that it's up to date and it's actually correct information. I faced 3 challenges, and I had to overcome those challenges. Well, I'll tell you a bit about the challenges. The first challenge was that the first people I dealt with didn't want me to trace my origins. They didn't think that it would be good for me. And I didn't agree with them. I felt that I had a very huge emotional void that was creating a lot of anxiety in my life. I had documents, I had my adoption papers and names on them. So with that, I was able to do a bit of research on social media. But Facebook doesn't have filters to help you verify whether the information that you have, that you're using to carry out your search is correct, whether it's real. So I got a lot of strange responses and a lot of rejections. So I gave up looking down that channel. And to be honest with you, it frightened me a little bit. So I sort of brought things to a halt there. My second challenge was to find a safe and reliable mechanism that would help me find my origins. So I spoke to my psychologist about it, and there was actually a database of DNA, a worldwide database of DNA available to people who were trying to trace their origins for whatever reason. And it's thanks to the DNA test that I took, I was able to sort out who could help me and who couldn't, and find the right path to follow. I found a second cousin in Spain, and thanks to her, I was actually able to track down my birth parents, and she put me in touch with them through Facebook. And the information that they were giving me was exactly what was on my adoption papers. So I was able to verify that. So once I'd been able to trace my birth parents, I had to contact them and face-to-face talk to them and get as much information about what had happened as I could from them. Anyway, I then came up against my third challenge, which was meeting them face to face and having that conversation with them, and also have the certainty that they were who they said they were and that there was nothing fishy going on. Thank you.
Thank you so much, Claudia, for that. Certainly laying the ground for those, the discussions will build on a bit later. Thank you so much, Claudia, for that. Certainly laying the challenges that are faced by the discussions when they search for origins, I think, build on a bit later, but already indicating to be one of the most important takeaways from today's discussion. I think, again, it was highlighted. Let me allow Michaela to just give us a brief introduction of herself and takeaways from today's discussion. Let me allow Michaela to just give us a brief introduction of herself and a bit about her journey with adoption. Thanks, Michaela.
Yes, good afternoon, and thank you very much for giving me the possibility to share with you our experience. I'm from Italy. I am a teacher, and in 2016, me and my husband decided to adopt 2 children. Our children were born in Colombia, where they lived when they were adopted. Samuel and Juan Jose had 7 years, Samuel, and Juan Jose was nearly 13 years old when adopted. And Juan Jose had an important role during all the stages during the adoption, when they stayed in Colombia, where they lived in families. They moved sometimes, and they stay in families. But his role was really, really important.
Thank you, Michaela. And we will also come back
process.
To that journey of you adopting, from Colombia. Thank you, Michaela. We will also come back to that journey of family and what you adopting. And then I will now go to Marie to just do a brief introduction with the birth family and what that entailed. Process and then I will now go to Marie to just do a brief introduction in relation to her process and her journey with adoption, having been adopted from Mali in Africa. Marie?
Thank you very much for inviting me. I'm 35. I was adopted in 1989 by a French couple, who had already adopted 3 children from South Korea. My parents followed the process through the same organization with a lot of experience in international adoption, in inter-country adoption. I was always aware of my back history. My mother gave me up because she was poor, and the adoptive parents traveled to my country of origin to adopt me. When I had my first child, I felt the need to tell my children my story, and thanks to my adoptive parents, I was able to trace my own origins. I had also done some research on the internet. I found as much information as I could, and heard things from a lot of people. There was a lot of talk as well about illicit adoption. So I needed to know whether I had been legally adopted or not. And I wanted to find my birth mother. So in 2020, I decided to go to Mali for the first time in my life. And through the media and through the French speaking radio and through Le Monde, I was able to investigate the adoption processes existing in Mali. And through the papers and the radio station, I was able to find my birth mother. Somebody actually recognized me because apparently I looked very much like my birth mother. And I was told, or they told my mother, that they'd seen me on the television and that I'd been looking for her, and she'd been looking for me for many years. So I created a group of Mali adoptees in order to help other people and to combat the illicit adoptions, both in Mali and the rest of the world. We brought together associations of adoptees, adoptive parents, and birth parents, who are all fighting to protect the interests of adoptees and help adoptees find their birth parents.
Thank you very much, Marie. Thank you, everyone, for those introductory remarks and getting everybody to understand your starting point for today's discussion. I will now turn over to the flighting of the video from Madam Janet Osorio, who is in Colombia, who we had to pre-record for her to be able to participate in the session. I think the video will take at the very most 18 minutes, and then we will pick up the discussion with the other panelists after that. Thank you. Thank you so much. Good morning, Madam Janet, and really thank you for joining us on this session when we are celebrating the 30th anniversary of the Adoption Convention. As a biological mother or birth mother who gave her child up for adoption, we value your time in sharing your lived experience with us. I understand that it's been a while since you gave your child, your daughter, up for adoption. But we thought we could learn from you a bit about what happened during that process where you gave your daughter up for adoption. What led to that? What were some of the options that were shared with you in relation to maybe keeping her with you instead of giving her up for adoption? And more importantly, what did the process of giving up your child for adoption entail?
Good afternoon, everybody. My name is Janet Osorio Nogales. I'm a birth mother who has been involved in the adoption process. Thank you very much for inviting me to this anniversary celebration. Well, what drew me into the adoption process, I'll describe to you. I mean, my circumstances were that I was a mother. I had 2 daughters. I was on my own. I had a poorly paid job, so it didn't pay me enough to cover our needs. So, you know, I was a young mother. I was recently separated. And so it wasn't just the economic situation, but also the emotional circumstances that I found myself in, having to support 3 people at that time. And although my mother was aware of the situation that I was in and what I was planning to do at that time, and although she did offer to help me, it was a decision that I took as a woman. And it was more my emotional circumstances that led me to that situation I found myself in, having to deal with it on my own. So as a biological mother, you have the sort of novelesque options. You can perhaps leave your child on a doorstep, or try to find whatever means you can to support your family. But really, what you need is an institution that can help you to do things properly and legally. You have to understand whether the adoption is legal, how things work internationally or even nationally, because really it's quite a taboo subject, really. And information is something you have to find for yourself. You have to research it, and not all biological mothers are in the same situation. Not all of them, for example, have access to internet. And also your cultural background or your education isn't, you know, the same as everybody else's. Not everybody is the same. And a lot of people are full of fear. They may be in a situation that's the result of a violent rape, or some may have been in a relationship and they've been abandoned. But I think this is the decision that you make that's better than opting for an abortion. It's the healthier of the 2 options. It's painful, but it's healthy for both parties, both for the mother and the child. So this happened to me 22 years ago, and I really do think it was the best possible thing I could have done. There will always be that feeling, or that sort of wondering of what will happen if you meet the person in the future. I mean, that's just one of those things that you carry with you as a biological mother.
Thank you so much. I think as an additional question to that response is, when you made this decision, were you given counseling? Were you given any kind of support to enable you to make that decision in an informed way? And then also just to maybe share with us, when you eventually then gave up your daughter for adoption, did you leave her with something that would help her to maybe at a later stage trace you insofar as knowing who her biological parents were?
Well, I took the decision quite late on to give up my daughter in adoption. It was one of those situations, considering that she was the result of a non-consensual sexual act. It was a rape. It was a non-violent rape, all the same. So when you find yourself in that situation, you kind of don't believe that it's actually happening. It all happened very quickly, and the Institute of Family Wellbeing and the Casa de Adopción, or the adoption home provided all the support and accompaniment throughout the process. And some women decide to do this from the first month of their pregnancy, but that wasn't my case. I had to continue to support my daughters. I had to continue working, and that's one of those situations that you don't expect to find yourself in. You don't expect to have to go into a hospital or have constant checkups, etc. But these institutions provide the tools, and they can answer your questions, and they can accompany you. But also there is a financial side to all of this. The adoption homes can provide some activities for you to do, but you don't get paid for doing them. So I think that's something that needs to be provided for. I don't know whether adoption homes in other parts of the world, or whether in Colombia it's the case now, whether there is that option for mothers who decide to go down that route, receive some sort of financial support money that they can send home. In my case, that didn't exist, so I was forced to continue working and hide my pregnancy. My mother did offer to help me, as I said before, but the decision was really mine. So I guess in that respect, I didn't get that support or that help. However, I was offered two possibilities. I could either keep the baby or give her up for adoption. So unfortunately, you can't just keep the child. You have to look into the future and consider the financials and think about how you're going to bring the child up, clothe it, feed it, give it an education. And as a biological mother, I thought, a baby, I've already got 2 children. How am I going to work? Who's going to look after the baby? I mean, aside from the fact that she was the result of a violent rape, or that the child might be from a rape, or even conceived with someone who you love. Those are things that you need to take into account. So those are the 2 options that you have in front of you. But for me, what was important was that adoption as an option is something that, you know, you have to consider and weigh up all of the options and what's going to happen when you have a baby. I mean, you could think about it and ask yourself, what's the best option, the healthiest option, a way not to harm anyone and give a child that has no fault in all of this the opportunity to live a life, and for you to draw some strength from the experience and grow. And also keep in mind that at some point you might meet that person in the future, if obviously both of you want to, because there may be situations in which the birth mother does not want, for whatever reason, to meet that person, and you know, that's fine. So for me, that was important. It was important for me to know that adoption is like a bridge to life for some women who are unable to have children of their own, right? The difference there is just the baby is carried by you inside of your womb. I've studied many cases of adoption, and that is the process basically that is gone through. It may take 2-3 years. There's a lot of documents involved, a lot of things that need to be done. And that is, to my mind, like a pregnancy. It's like carrying a child. So that may be a different way of having a child, but the circumstances at the end of the day are the same. And when I met my daughter, I saw just how committed the adoptive family was. It was spectacular for me. It was really emotional to see their reaction when the child was handed over. It really was like a birth, all that joy, all that emotion. It was lovely, and it does give you some peace of mind because you know that the adoption is real. If things are done properly, if they're done in the right way and people are counseled properly, and that everything be done within the law. In my case, adoption was the best tool at that time in my life, and I'm very thankful. I have no remorse, no pain, totally the opposite. And I am very grateful for adoption because it helped me to grow as a woman and as a mother. And my daughter went to a home where they were able to offer her economically and emotionally everything she needed. And that was wonderful. And I'm really grateful to the adoptive parents. They are people who could have said, oh, I want a white child, I want a dark child, I want a child with curly hair. But they, in many cases, adoptive parents just accept what's given to them. Some parents adopt children with disabilities. They could have had a healthy child, but that's love, isn't it? And to feel that love, you don't have to necessarily carry that a little person inside of you.
Thank you for that. My understanding is that then a few months ago, I think towards the end of 2020, there was a process for you to reunify with your daughter. My understanding is that she was looking for you. Maybe you can tell us a bit about that process of reunification. Particularly how did that happen? How were you approached about the reunification? What preparation went into making sure that before you meet your daughter, you are in a space where you have been counseled, and also who provides the service for you, because that's very important for all of us to understand how different countries deal with this aspect of preparing biological parents when they meet with their children that they've gave up for adoption.
Well, I left, in answer to that question about whether I left my daughter anything that would help her in the future if she decided she wanted to know her origin. Well, first of all, I'd like to say how grateful I am to the program that department called Research for Origins, because they provide the tools necessary for adoptees who wish to trace their origins. But that's only possible if the birth mother wishes for that to happen, and that's fine. In my case, my family was aware. Years had gone by and my daughters had grown up. I had a new partner, and I at that point felt that they needed to know about the decision that I had taken, because I knew that at some point it would happen. I would be reunited. So with that in mind, I left a letter with the adoptive parents and my daughter, so that when the time came, when she came of age, if she wanted to, she could search for me. I mean, some children don't wish to do that. They're quite happy with their circumstances, and that's that. But in my case, what helped was the letter. But we have to remember that my case was very clear, cut and dry, and everything was very neatly tied up. And I'd like to thank the Institute. I'd like to thank the adoption home for giving me the opportunity as well to breastfeed my daughter. In some cases, I understand not many birth mothers are able to do that. And in other cases, if they are allowed to, they bond and things get a bit more complicated when the child has to be handed over. But it also helps sometimes to make your decision. So it may be that over a period of time, the mother changes her mind and she decides to keep the child, and she's allowed to. It's not like they tear the baby out of your arms and say, well, you said you wanted to put it up for adoption, so that's that. No, you have 30 days after signing the consent forms to change your mind. You can say, no, I want to keep the baby. And that's the end of that. And that was very clear in my mind as well.
Well, thank you so much to Madame Janet Osorio from Colombia. In her absence, she really has provided us her lived experience, which obviously there may be some who do not fully agree with her views on certain aspects, but that is her journey and her lived reality and what she went through, certainly highlighting the complex nature of the process. That's the first thing we pick up. But the second thing is that she did have some support right from the start in that process and made a decision to try and, in her view, give a better opportunity for her daughter. And lastly, highlighting the point where the process for reunification was taking place and how the fact that she had at least left a letter for her daughter in case she wanted to know a bit about herself later, that is the reality of her life and the journey that she went through. And we're grateful that she has shared that with us and certainly gives us something to think about. The video, the full video of Ms. Osorio might later be uploaded on the HECHC website as we, due to time constraints, we cannot flood all of it, but we will touch on some of her other points she made during the interview, particularly in relation to this process of reunification and tracing origins. So from a birth mother to an adoptive mother, I'm going to now bring us back to the panelists who are here with Michaela first. Michaela, you heard Madame Janet's story as a birth mother giving up her child for adoption, but we want to hear from you as an adoptive parent who had two boys who were not that small and had some understanding of the process probably, but just take us through your journey of how the process was done, which is obviously under the convention, and also, what did the process entail insofar as making sure that Samuel and Juan Jose themselves understand what was going on, and how were they prepared for that process, and also if they were asked for the explicit consent to being adopted by you and your family. Thank you so much.
You're welcome. Yes, first of all, yes, we as adoptive parents were supported here in Italy by not only the authorized body, but above all also from non-profit association. They helped us, they prepared, and they supported us as training in parenthood and in building a new view in relationship with our children. And we were helped also in preparing all the documents and in receiving all the right information. We were informed about the possibility to adopt Juan Jose and Samuel in April. We immediately say yes. On the other hand, Samuel and Juan Jose were living in a family. And 1 month later, in May, they had the possibility they were informed and they received information about our life, our job, pictures of us, and they were asked what they think about. And so they had the possibility to say yes, or we are not interested. And they were supported by the Bienestar Familiar and all the professionals till the end. It is really very important. And the main role was Juan Jose's one, because they were 2 children, and Samuel was 7 years old. He hadn't great memories of his past because he was only 5-6 months when he stopped living with her birth mother. But Juan Jose, he knew very well their story, and they when they had the possibility to meet the last time, their birth mother, Juan Jose, said that he was not interested in restart living with her, and because the psychologists and the professionals helped Juan Jose to know his feelings and his point of view about his future and his brothers too. So we were supported in Italy, and on the other hand, they were well supported in Colombia. So they consented to the adoption. They consented to the adoption, and they had time to reflect. In fact, immediately later, they moved in another family because the Bienestar Familiar started to prepare to train them for a new life. So they stopped living with the family where they were living. They stayed 2 months in a new family because they prepared them for this new approach. And they were prepared also from different point of view. For example, to move into another country, other language, everything. Above all, from a psychological point of view, they received great support. Thank you.
Thank you so much, Micaela, for sharing that. Clearly, one of the important things is also showing that because the convention is there is a framework for support, and all the processes need to actually align with what the convention says. We will now go to Marie. Marie, who was adopted in 1989, obviously prior to the convention, from Mali, and at a young age from Mali to France. Marie, at this moment, we would like you to share with us in relation to the fact that when you started looking into your origin and your background, you found that there were challenges and that there was an issue with the possibility of illicit practices having been there when you were given up for adoption. So maybe you can tell us, how did you discover that there were illicit practices, and what did those illicit practices entail? What was the stuff that had gone wrong in the process of your adoption? Thank you.
When I wanted to start finding out more about my origin, I looked into my parents' adoption dossier and also the headquarters of the organisation that had taken care of my adoption. I could see that there were different dates of birth, differences as regards place of birth, and there was just some, we could see that things had been typexed out, where there was my biological father's name that was blocked out, even though it said that there was no biological father, that his identity was unknown on my birth certificate. And so it turned out that they said that that my mother had just wanted to basically play along, that she was still interested, and then she, with a few photos, you know, she was, but then afterwards she wasn't interested. This is what the letter that my parents had received. And then I also got birth certificate from the actual town hall when I went to Mali, and they didn't respond to what was in the civil registry, and the person at the registry office told me that the document was a fake. It should be known that in Mali, only children who have no parents can be adopted. Those whose parents are dead, etc., can be adopted. And there's another type of adoption, which is parents that have not died. This is an alleviation of parental authority, a simple adoption, but there was no consent to the adoption, to the abandonment, and so basically there was no decision by any sort of court because my mother was alive. So we could see that it was turned into a full adoption, but there was no consent to the adoption, nor was there any consent to this an alleviation of parental authority by my birth mother. So my birth parents have said that they were told that the child would basically be taken away for their own education, but they'd be able to come back to Mali regularly. And they only, they'd been told to, my parents had been asked to send, you know, reports every 6 months. And that was to be sent to the French authorities or the Malian authorities. But in fact, these reports were sent to the to my birth parents, which basically fed what they thought, that I was going to come back. So basically, there's other relatives that I had. There was other biological, there's other people, biological children who are in France, and their parents had absolutely no idea that this was going on. And unfortunately, I'm not an isolated case.
Thank you so much, Marie. Certainly highlighting the importance of a process that is properly regulated, particularly in ensuring that information that is kept for adoptees is accurate, is not fraudulent, but also more importantly, ensuring that laws are complied with once they are in place. And I think, as you say, your journey was prior to the convention, I mean, the adoption, and your journey now highlights how, because the convention requires certain prescripts, certain things to be complied with, maybe that could alleviate some of these challenges that are faced by adoptees when they try and trace their origins. And I think Claudia will elaborate also on this aspect of the difficulty of the journey of tracing your origins. Claudia, earlier already in your introduction, you touched on the fact that you made use of DNA testing, as well as Facebook, which obviously have become tools for people search for origins. However, those tools don't come uncomplicated or without their problems. And I think at this moment, you can maybe share with us how this journey unfolded, what were the challenges that you faced, and what support did you get, if any, in this process of trying to use social media and other forms such as DNA testing to try and trace your birth family?
Well, my first source of support was my fairy godmother, as I call her. That was my psychologist. She realized that in order for me to sort of allow myself to scar, so as it were, those wounds that I had to find my origins. She recommended to me that, as well as DNA, she recommended that I start looking, contacting with the origin search program of the the Madrid community. I really received the best possible treatment there. The director of that initiative was an absolute star with me. And I was put in contact with the Romanian authorities thanks to that. I'm very thankful to them for that. And Antonio Fernandez and the director was able to verify the papers that I had, adoption paperwork, and they were able to verify that those were real, they weren't fakes, that the information on my paperwork was what it was. I then understood and found out that I had brothers and sisters, more siblings, but that was a process, the support of my authorities, you know, psychologists, my parents, and the authorities on both sides.
Thank you so much, Claudia. And I think this links very well with one point that Madame Jeanette made in the full video that I mentioned will be shared later, where she also spoke to this process of tracing origin and highlighting the importance of having a proper system in place and authorities that are designated to assist adoptees, adoptive parents, and the birth families in this journey of tracing origins, because it's not an easy journey, and there's a need for support, for counseling, and particularly, you know, I think the big point that comes from your story is that also using the social media platforms sometimes come with challenges as well. So you need the overall support. We cannot leave it that adoptees will find their birth families through searches for DNAs online and all that. And that is a big takeaway, that the states have obligations to ensure that adoptees are fully supported when they start the journey for search for origins. But it also takes us back to what Marie shared, is that there has to be information that was accurately captured to start with. That is information that can be verified and not falsified, and so that it can really help adoptees in this journey of finding their origins. Thank you so much for that. I want to go back to Michaela. Your the adoptions for Samuel and Juan Jose took place in 2016. So you shared how the children themselves were counseled and needed to give consent and all this, and you shared already a little bit about how you were prepared about, for the process of adoption. But can you maybe just highlight, you know, further to the support given in preparation in that process itself? Were you told and were you counseled with specific focus on the issue of searching for origins, knowing that in future there could be this process for the children to now want to get information about their birth family, and how would that, you know, what support would be there, and how would you also deal with the children wanting to maybe know about their birth family? And maybe you can also share a little bit about whether the children themselves, as they are aware that they were adopted, have shown interest in knowing about the origins, or going back and just reflecting a bit about their birth family and their role in their lives. Thank you.
Yes. As you know, Juan Jose was the elder, so he had memories of his past life. He knew his birth mother. Both my children didn't know their birth father because they didn't have the same birth father, because her mother didn't have stable relationships. And so Juan Jose doesn't know as Samuel their birth father. Anyway, they were prepared, and first of all, the first important thing is that Juan Jose met many times their birth mother when they lived in families, in foster families, and Samuel at the very beginning didn't understand that the family in which we were living, it was not his birth family. Then, after some years, psychologists, and thanks to the Bienestar Familiar that always supported them, he knew. And when Juan Jose told him all their story, he both preferred to choose the adoption for their future rather than to choose to stay with their mother. And so during the last meeting, both expressed the desire to be adopted. We received all information and all files from the very first year of their life. We have everything. Bienestar Familiar gave us all the documents. So 2 years ago, more or less, Juan Jose told me he wanted to read the documents because he wanted to face what is written, what is written, and above all, he wanted to know if files reflected the reality of facts. So when he stayed, he read everything, all documents, all files, and he told me that what we have, the same documents that we read before adopting them, faced the reality of facts. And it was really important because I think that in that moment, he closed the circle of his life and he well understood that he told me that it was sure to be the right thing for himself and his brother, and because his desire of new life likely happened. And the other important aspect is that he knew their origins. He know their origins, and in documents, in files, everything is written in the right way, and they do not need now to search more because they have the information they need, and they know that in documents that we have in our house, the story reflected the reality. Yes, they were always supported by the professionals of Bienestar during all the period before and after. During the follow-up in Italy, they were supported both, all the family. We were supported by no-profit association that helped us to start again, everybody. Yes.
Thank you so much, Micaela, for sharing that with us. I think the most important aspect coming from your sharing is the centralization of the children, because this is their journey. And that is central to the convention, and their adoption took place under the convention. And it is encouraging to see that because of that framework being there, it seems that countries both of origin and countries where children are adopted to are doing their best to ensure that there's compliance. There's now a file in case the two young men now wish to make contact with their birth families. Thank you so much. Marie, just talking about the point of support, let me come to you. You already touched on the fact that you have established an organization of adoptees to try and help them in relation to this issue, particularly the quest for searching for their origins. Maybe just tell us a little bit more about this association, what support you provide, and what other areas of support could improve insofar as helping adoptees find their birth families and being supported in that journey. Thank you.
Yes, in fact, in 2020, I founded the collective for people adopted from Mali. When I went through the process myself, I was kind of doing it on my own, there was no one that had contacts with Mali. When I was researching my own case, I had collected a lot of information in order to tackle my own case, and I wanted to put that out there to support others who it might help to find their own origins, and people who want to try and find their biological families. such as, you know, really important people like Jilly Condé, who is really an important person in Mali. And, you know, we also give people the chance to get to know Malian culture. A lot of people don't know about their own culture, and they maybe don't feel quite that they dare approaching the diaspora from Mali. And so we have different people who are active in those areas that help us. And so we've actually brought legal action against the organisation who basically arranged all of these illicit adoptions, and the people that were the contact people at the time. And the judge had opened an investigation in that vein. And so we're actually accompanied by lawyers from the Human Rights Alliance. And so we want to try and find out about different inter-country adoptions that are illegal. And we have contacted different ministers and members of parliament. And as well, I mentioned Voices Against Illegal Adoption, where we actually work with UN experts on the subject. And so we want to try and bring together exchanges at international conferences where we're able to propose different activities through different collectives. I think it really is important that people, you know, that get involved in these kind of things that might not ever dare trying to search for their families might end up getting the necessary bravery and support to do so. I think that there's an immense disparity regarding different countries around the world as regards the resources available to help people. In France, there's no organisations dedicated to people that have been adopted abroad into country adoptions to help them find their origins. No support, administrative support, social support, psychological support to accompany people on this path, which can be very difficult. Whether this adoption took place illicitly or legally, whether the dossier is complete or incomplete, you could come up against language barriers, cultural barriers, psychological barriers, financial barriers when it comes to actually getting over to the origin countries. So there's often just a lack of contacts with officials in the country, and people just don't know where to turn. And so they basically find themselves that they're out on their own when they're trying to find their origin and their birth families. And then what's the actual setup and relationship with the birth family? How's that all going to pan out as well? And then as regards the DNA testing, in some countries this is legal, in France it's not. And so sometimes, nevertheless, this is the only way that you would be able to find those family links. Or to even prove it when you think that you've found your birth family. So I think that countries do need to look at whether that should be legalised or not for these types of cases in reception countries and origin countries. And there's also been a joint declaration that was drafted by different UN expert committees and special rapporteurs from the UN as regards illegal inter-country adoptions, which gives a certain number of recommendations that states should follow so as to prevent, recognise, condemn and stop all forms of illegal inter-country adoption. And so we have to make sure that all states that are parties to the Hague Convention do actually take these steps so as to allow this right to find out their identity on the part of these people adopted. So I think that really is important to bear adoptees in mind, you know, when you come to legislate on these things, because they have an experience and an expertise that for me is absolutely necessary, because they're at the centre of absolutely everything that we're talking about as regards inter-country adoption. Thank you.
Thank you so much, Marie. Certainly centralizing the adoptees again, but just to say that what I would add to what you've said is you should remember, as in your case, and you've been so resilient and even started an organization to help adoptees, is that we should not forget those that took place, particularly before the convention, because that is where most challenges lie, and that's where most people face challenges, particularly with tracing the origins. So states also maybe, that is something that should be central on their agenda, how to deal with the pre-convention adoptions and assisting the adoptees. Yes. Claudia, I'm going to come back to you as we draw close to our session, just for you to give us the recommendations that you would make to adoptees who want to look there for birth families, or who have tried to look and are struggling to find their families. What advice would you give them? One of the things that earlier Madam Janet said in her recording was that, finding or going through the journey of trying to trace the origins is a journey of resilience, and you've been through that. You've already highlighted the challenges, but what would you say to other adoptees out there in relation to this process?
Well, first off, I'd like to say that I've got some quite bad sound quality. Perhaps you won't hear me very well. I'm going to try and raise my voice. I think that we need to have this support from your own family and psychologically as well. I think if you feel that you're out on it on your own with all of this, it's going to be really complex. I think we have to also transmit to psychologists and people who help adoptees that it's really important that they do find their origins, because I think it's the only way that they're going to be able to fill that gap that people tend to have that have been adopted. And I think that we've said that in some countries it's not legal. I think DNA testing is important, because then you're able to move more directly, move forward, that is, as regards what you're looking for. And I think that at the end of the day, if you start looking through social media, you could end up putting yourself up there for getting it wrong and further being incorrect connections made. So I think that when I finally found my family, it did in the final stages end up being quite easily once I'd unblocked certain stages to get to my birth family. I think that that we have to be able to search for origins. This search mechanism is a really useful tool, and I think that it's of great support for adoptees. I would also tell other adoptees like me that this is a decision you have to take on your own, because if you're not prepared to go down this path, it can be very difficult as well. I think that the older you get, the more of a need you have to discover where you come from. And I think that it's finding out what the best way to move forward with this is. Thank you.
Thank you so much. I think I have we have a minute, a minute and a half. If I'm stealing some time, we already stole a lot of time, but I'm going to just go around to just ask you, just one final kind of recommendation, as a takeaway to this celebration, and so that in 10 years' time, you can see if recommendations were heeded or not. But maybe let me start with Michaela. Michaela, if there was one recommendation you can make from your side in relation to adoptions, what would that be?
Yes, thank you. It is important. A final wish is that we always be focused on the children's rights, and it is important to support both parties, both actors. On one hand, the adoptive parents need support during and above all after the adoption. In the first period, above all, in Italy, for example, we have important guidelines that we can find and that can give us support to all the family for school inclusion. During the school inclusion, it is really very important, because teachers there is a training period, and it is very important to have guidelines for both parts. And on the other hand, it is really very important to support children and to give them the possibility to be in touch with files, documents, to know the truth, because they search the truth. In our experience, they knew the truth, and so files reflected only what they just knew. But it is really important that children can consent to the adoption, for example, and to give access, simply access to documents and files to match their origins.
Thank you so much, Michaela. Marie, any last wish, last recommendation from you?
Well, my wish would be that the states listen to the increasing number of adoptees and the movements that they represent, both from their receiving or host countries and the movements in the countries of origin. It's very important that there be documentaries, that there be awareness building, so that the public understands people's rights to their identity. Thank you.
Thank you. Claudia, 30 seconds for you. You already kind of gave quite a bit in relation to the search journey, but anything else you would put on your wish list?
I would say the same as Michaela and Marie. I think it's comforting to hear what the panelists have said, that adopted children need to have a safe place where they can express themselves and speak out. Obviously, we want to be heard. So it's good to hear from the families too, but we need to be heard.
Thank you so much, Claudia. With that, I think this has been a very informative and rich discussion, and we're really grateful to the panelists for sharing their real life stories to get us to reflect about the journey of adoption. We really appreciate your time, and I hope that you know, the wishes do come true, or the recommendations. So we will now take a 10-minute break.
Good morning, good afternoon, good evening to all of you, and welcome again to this second part of this online event. So I am Capucine Pajama, legal officer at the Permanent Bureau of the HCCH. And it's a pleasure to be here, and so I'll have the honor to moderate this third roundtable. And during this third roundtable, so we'll continue to discuss inter-country adoption, but this time looking to the future. And I'll have the pleasure to have this roundtable with Miss Bernadetta Berro, who is an independent expert, who is also the former executive director of the Inter-Country Adoption Board, as well Mr. Antonio Ferrandis, who is the head of the Adoption Service, the Central Authority of Madrid in Spain. We also have with us Professor Benyam David Mesmour, who is a fellow at the Harvard Law School, the Human Rights Program, and is also a member of the UN Committee on the Rights of the Child. We also have with us Marketa Kaserova-Navakova, who is the Deputy Director for the Office for International Legal Protection of Children, which is the Central Authority for the Czech Republic. And we also have with us Miss Charlotte Lutander, who is a social worker working at Adoption Centrum, and she's here representing also Euradopt and the Nordic Adoption Council. So it's really a pleasure to be here, and I'll start already with the first question. It's actually a question to two of you, Benyam and Antonio, and I'd like to hear from the perspective, so Benyam from the perspective of the state of origin, and you, Antonio, after from the perspective of the receiving state. Is inter-country adoption still needed today? And is the 1993 Adoption Convention still needed today? So Benyam, we'll start with you. Thank you.
Thank you very much. It's a pleasure to be connected, and it's an absolute treat to be able to connect and see some of the names that I recognize for the last 15, 20 years. Now, let me start with a disclaimer. Most of my experience is informed by the two treaty bodies that I had the privilege to serve on, the UN Committee on the Rights of the Child, but also the African Committee of Experts on the Rights and Welfare of the Child. Now, is adoption still needed, particularly intercountry adoption? If you look at the most recent developments that the children's rights space has been affected by in recent years, for example, it doesn't require anyone to go anywhere beyond than looking at UNICEF's annual report that was just published yesterday or the day before yesterday. So you look at the impact of COVID-19, you look at the impact of the migration crisis, you look at the link between children that are deprived of their family environments and the Sustainable Development Goals. You look at the debt or poverty cycle that quite a number of African countries or developing countries in general are finding themselves. You can also look at the natural disasters linked to climate change. Some of the debate around the advancement of technology, including on reproduction and so forth. Quite a lot of this point in the direction that adoption is still needed. There are specific group of children that often find to fall between the cracks. I had the opportunity to look at the last 2 years jurisprudence of the UN Committee on the Rights of the Child, specifically looking at intercountry adoption. And there are a number of elements pertaining to, for instance, children with disabilities and the institutional frameworks that needs to be consolidated and so forth. Now, so those point in the direction that it is still needed. Now, but don't take it from me, because the other way of looking at it is, are there countries that are still making progress on their laws and on their policies and their institutional arrangements to actually cater for adoption, including intercountry adoption? And the answer, once again, is in the affirmative. If you look at the last 1 year jurisprudence of the UN Committee on the Rights of the Child, for example, Azerbaijan, we gave a recommendation saying the committee welcomes the amendments to the Family Code in 2019, including mandatory consent of a child to his or her adoption. If you look at Mauritius, we gave a recommendation saying the state party should finalize the draft adoption bill. We gave a recommendation to the Philippines, saying the committee, noting the adoption in 2019 of the Simulated Births Rectification Act, recommended a number of elements that also have resonance for adoption, including intercountry adoption. We gave a similar recommendation to Bolivia, saying the committee takes note of Act number 1371, modifying the Children and Adolescents Code and the simplification of the adoption process and so forth, so forth. So there are still quite a number of legislative, administrative, and other measures that are actually being taken at the domestic level by states themselves, majority of them country of origins, that actually sends you the signal that still adoption is needed and still the 1993 convention is relevant. Now, on the last part, in relation to the relevance of the 1993 convention, previously the work of the Committee on the Rights of the Child in terms of asking states to ratify the convention was very central to the work that we did. Not so much. Sorry about that. So not so much, but it doesn't mean that we've actually, we're not giving, it doesn't necessarily mean that the committee's attention on the importance of the Hague Convention has dwindled. Actually, the other way around. We still give recommendations pertaining to institutional arrangements. We still give recommendations about deinstitutionalization and the role that intercountry adoption should play. We still give recommendations about the right to identity. We still give recommendations on issues about improper financial gain and so forth, so forth. So for me, it's a no-brainer. It is still needed. And the convention, the 1993 convention, as I often like to say, is not counting its days, it's making its days count.
Thank you so much, Benyam, for this response. And Antonio now as well. Thank you.
Yes, thank you very much, Capuchin. And also, thank you to the Permanent Bureau who've given us the opportunity to address you at this meeting in Spanish. Just as Benyam has stated, adoption in general and inter-country adoption are still necessary if there is a child that is lacking a stable and safe family environment. And in 2023, and most probably throughout the next decade, there will still be many children who have no parents to look after them and no family environment to which they have a right. They don't have any family around them. So having heard some of the concerns that have been voiced during the first roundtable discussion, I'd like to remind us that if we've learned anything from research and from past experience, that the threat to children's well-being is not fostering or adoption, it's being institutionalized. And anybody who works in the field of child safeguarding knows what institutionalizing children represents and means. It's not just a case of children whose childhood was lost in an institution and whose childhood went by. And there may be cases of that. And we've heard some quite hair-raising stories. But institutionalization is in itself the biggest threat to a child's welfare. So laws must clearly establish the maximum time period that a child can be put into care, provisional care. And this is not just something that is recent, but it dates back many, many years. There may be children who have had long periods of time in care. For example, 5-year-old children who from birth have been institutionalized and they've not had visits during that period from any member of their family, perhaps due to preventive measures or due to concerns surrounding the child's situation. That's why certain rights are being violated. So multiculturalism, immigration, migration have made the world a global village. And that means that the family environment is the best place for a child, even if those families are a far, far distance away. That's where children need to be. And what's important is that those of us who work in this sector, that the UN Convention of '89 on Children's Rights and the Hague Convention of 1993 have become two essential instruments for the defense of the rights of children. Private adoptions have disappeared in our scope of influence, and we now have an organized procedure that is carried out through the correct authorities. We all have a shared goal that children's well-being be safeguarded. I would go so far as to say about the convention that in this century, the risks around are no smaller than they were back in the 80s when the text was drafted. They may even be greater now, because if we look at the statistics, that's what we can see. And in other areas of our scope of activity, there are still activities ongoing, and we cannot let our guard down in terms of illicit practices. And just like in the past, it's extremely important that there be very close cooperation between authorities, and that's both in the countries of origin and in the receiving states. Last week, a family that was just starting out on their journey asked us, well, are we going to have the certainty that the child that we adopt hasn't been illegally taken from its parents? And my answer to that question is important. It's important that I be able to say, yes, you can have that guarantee. Thank you very much, Antonio.
So thank you as well, Benyam. So thank you to both of you for sharing your perspective on this question, to share as well the that for you adoption is still needed, but that we still have to be vigilant on the need to properly apply the 1993 Adoption Convention and also the UN Convention on the Rights of the Child. let's move now to the practice of the authorities and bodies. And I have a question now for Markéta. So the Czech Republic, the implementation of the 93 Adoption Convention has evolved in the Czech Republic. So could you please explain those changes to us and how do you see them being applied for the future?
Thank you, Capucine. Since the Czech Republic has become the party to the Hague Adoption Convention in 2000, the practice and also the amount of cases has been significantly changed. In the beginning, the Czech Central Authority decided on placement of the child on their own. Later, we started to cooperate with psychologists concerning the assessment of the pups. Later, the advisory board has been established, the body focusing on matching of children and prospective adoptive parents, consisting of independent experts. In the end, instead of administrative decisions of the central authority, the court decides on the placement. The most important change is very intensive cooperation with psychologists and legal support from the employees of the central authority. The lawyers prepare the application of prospective adoptive parents for the court. They communicate with guardian of the child, with an institution or foster parents who care for the child. They organize the meetings of prospective adoptive parents with the child. The psychologists in detail inform of the medical and psychological situation and development of the child, and they assist at the first meeting between the child and the pups. During the stay of pups in the Czech Republic, they provide permanent support. They are available online or by phone during the whole stay in the Czech Republic, which usually takes from 6 to 8 weeks. The reason for more intensive work with the future families is also the different profile of children. It was already mentioned here. There are less and less children who are suitable for inter-country adoption, which is a positive trend, we mean. The Czech population is more tolerant to the ethnicity of the children and also to their health situation. Also, the better support is provided to birth families, and our aim is that the children could stay with their birth parents. Nevertheless, there are some children who are in need of inter-country adoption. Mainly, they are older, over 4 years, in many cases from 6 to 8 years. There are groups of 2 or 3 children, siblings. Some children are with very difficult psychological profile. The principle of subsidiarity is strictly respected. There must be provided that the Czech authorities failed to find an adoptive family or permanent foster care for a specific child for the time period of 6 months. That means that all the time there is same Hague Convention, but our practice has very significantly developed, and I mean that is a positive trend. Thank you.
Thank you, Markéta, for recalling the principle of subsidiarity and as well the importance of cooperation. Bernadette, I now have a question for you, taking into account your experience all those years. How do you see inter-country adoption and the implementation of the 1993 Adoption Convention in the future?
Okay. Good evening, everybody. Thank you. For the implementation, the future, I believe that there is so much more that can be done in terms of improving and strengthening the convention. For example, when you think in terms of globalization, this phenomenon of globalization, people are moving around the globe, and the specific example would be when Filipino nationals move abroad, they interact with the locals, they have children, you know, in these countries, and maybe for one reason or another, they could not bring the children back home. These children are left in informal placements. I feel that there is potential for the convention to help these children in and protect them, instead of putting them in this temporary and uncertain placements. Maybe the convention can expand somehow this adoption to allow both the central authorities of the country where the person came from and the country where they are temporarily stationed to work together to come up with a permanent solution for the children.
Thank you, Bernadette. And well, we know as well the importance of listening to those that have lived experience through implementation. And Marie also mentioned it. So, Charlotte, now I have a question for you. How do you see the role of adoptees in authorities and bodies working in adoption?
Thank you. Thank you for this invitation. And for me, it's an honor to represent Nordic Adoption Council and also Euroadopt. For me, it's always positive when professionals with lived experience, and there is no exception in the work of adoptions. And there is actually a strong history of adoptees working within and developing the inter-country adoption services within accredited bodies. And Nordic Adoption Council and Euroadopt think it's essential that adoption services are always up to date by the many different experience of adoptees, because every adoptee has their own story, of course. And we are also aware that some central authorities actually recruit adoptees. And when an adoptee speaks to another adoptee, I think it gives maybe more credibility, because no one can tell an adoptee, an adoptee cannot tell another adoptee that you don't know what I mean or what I feel.
Thank you, Charlotte, for recalling the importance of having adoptees throughout and what they can bring. I'd like now to move on to the changes of inter-country adoption that we have seen happening. Some of the changes in inter-country adoptions, they are well known. They have happened already for a number of years. But there are also other situations that are less known, that are more recent. And I have two questions in that respect for Benyam and Bernadette. I'll start with you, Benyam. So recently we've seen a change in the states that are receiving states, which formerly were only states of origin, and these states now that want to adopt in certain continents. And which challenges do you think these situations are facing, and what would you recommend for such cases?
Thank you very much. It's a very important point to reflect on. Now, let me make a preliminary remark. The Hague Convention of 29 May 1993 does not operate in a vacuum. It also works very much aligned with, for instance, the Convention on the Rights of the Child, but also the optional protocol to the Convention on the Rights of the Child on the sale of children, child prostitution, and child pornography. So that's an important element to keep in mind. The second important element to keep in mind is this complementary relationship exists, but the role that the Hague Convention tries to achieve, which is to establish safeguards to ensure that the best interest of children will be protected in inter-country adoption. That's absolutely critical. It's not just only relevant for sending countries. It's not just only relevant for receiving countries. It's relevant for all countries. The second element, to establish a system of cooperation. Cooperation is not a one-way traffic, it's a two-way traffic. It's relevant both for receiving countries, but also sending countries. And the third one, ensuring recognition of inter-country adoption. Again, it's not a monologue, it's a dialogue, it's a two-way traffic, and it's relevant for all countries. So personally, I have felt uncomfortable about the argument that, ratification of the Hague Convention will be more relevant to sending countries than receiving countries, or the other way around. At the heart of what they want to achieve, if we were to summarize it, is to promote children's best interest in the context of inter-country adoption. So it's relevant for all state parties to the Convention on the Rights of the Child, 196, and its relevance might be more for some and less for others, but it is nonetheless relevant. So that's an important element to keep in mind. Now, the other point that I just want to flag is, if we're talking about the Refugee Convention, for instance, I don't hear arguments that actually say, oh, the Refugee Convention is more relevant for the countries that are countries of transit or countries of destination. It's relevant for the whole gamut. So appreciating the whole gamut, the whole spectrum that is provided from the point of view of protection through the Hague Convention is critical. Now, some of these changes that we are seeing now, for instance, some countries that used to traditionally be receiving countries becoming sending countries and so forth. Part of the challenge is that they haven't embraced the convention, the Hague Convention, but also the other two that I just mentioned in their entirety. They haven't really understood what it actually means to protect children's best interest in the context of inter-country adoption in its entirety. There has been a very limited understanding of the concept, and that's one of the reasons why we see the challenge. Previously, there have been recommendations from the Hague Conference that even for the countries that have not yet ratified the Hague Convention on Inter-Country Adoption, they should try to apply the principles as much as possible in all their dealings, even when they're dealing with countries that are not contracting states. That shouldn't just be a mantra or something that we keep on repeating. It should be something that we actually embrace and realize that if we're really serious about achieving the Sustainable Development Goals, if we're really serious about our obligations under the Convention on the Rights of the Child, including on Article 21, if we're really serious about making sure what the Convention on the Rights of the Child says, children growing up in an atmosphere of love, happiness, and understanding, it's important to embrace the Hague Convention, both as a sending country, but as a receiving country, but generally as being part and parcel of the international community. Now, with the limited time, let me just mention a couple of other points. The resilience of our systems for child protection, including in the context of inter-country adoption, we shouldn't just assess them when everything is good and well. We should actually specifically assess them when things are actually falling apart. I remember during the time when the Zois Ark case in Central African Republic broke out. I remember the cases from Sierra Leone. I remember the cases in the context of the genocide in Rwanda and so forth. Some of those shortcomings that we have seen, that our systems are not resilient, is still happening now. So for the system to be able to be resilient, I do believe that sending countries, receiving countries, all members of the international community should embrace the Hague Convention and appreciate that the three critical objectives that it tries to achieve are relevant from countries from Afghanistan to Zimbabwe, that is A to Z.
Thank you, Benjamin. Everything from your intervention as well, what you said, it is a dialogue, and that the convention and its safeguards are really relevant to all states. So thank you for that. Bernadette, now from your experience, do you see any new situation in inter-country adoption that has recently been increased?
Well, for inter-country adoptions, the trend really is for the adoption of older children. So seeing that the trend is towards the adoption of older children, it is necessary also to see how the maybe guidelines on increased cooperation between the central authorities on how to handle this change in the kind of children that are being adopted. It is we have to make a change in the way we usually operate, thinking of what are the needs, the special needs of this new group of children that are being placed, maybe even more sensitivity to, well, the reasons why they're placed. In fact, in our situation, we request for more, say, information from the central authorities or the adoption bodies themselves to send us maybe a few words of translation to prepare the children better, as some sort of a dictionary. So it's really the preparation, in fact, the weather, the food. How do we best prepare the children for the new situation that they will be in? So we need this increased cooperation between both the receiving and the sending countries to ensure that the placement will not disrupt and minimize the possibility of any disruption.
Thank you, Bernadette, for raising with us these new situations that are happening, and as well, thank you for explaining some of the challenges that these new situations are bringing. Now, if we look at this question of challenges more broadly, I'd like to ask you, Antonio, what are the main challenges that inter-country adoptions faces today, and also which one they will face in the future, and how would you prevent and address them?
Well, it's a tough question. I would think I'd start off with saying that in the receiving countries, first off, we have to help public awareness to change their perspective, their lens on this question, on this issue. You know, we have to transmit this into public opinion. You know, basically this inter-country adoption is an alternative. It's not competing against national adoption, but we're talking about people that it might be more difficult to place with families because they're older or they've got disabilities or whatever, and I think this has to be reflected. It's not a market with fewer restrictions. So I think we have to speak about the fact that we have to continue bettering the quality and the trustworthiness of those reports from the children, the PAPs, the family, to facilitate the exchange of information, you know, and decision making. That's why the models proposed by the HCCH last summer might be a model for all different countries to follow, so as to be able to have more trustworthy and reports of a higher quality standard. Thirdly, I think we have to increase cooperation between legal personnel, psychologists, to combat, you know, child institutionalization. We have to work on the practical application of the principle of subsidiarity, which is provoked in some countries, you know, a fear of adoption that generates long waits in institutions where children grow up deprived of parental care. So today, we know the importance of the care people get in those first early but all important stages of life, and maintaining children in the first years of life and there onwards in institution due to the whatever reasons there are can actually cause irreparable damage in the development of those children's brains and in other areas, you know. So I think we have to speed up decision making. I would like to say the fact that the Article 35 is the shortest of the convention doesn't mean by any means that it's the least important. Competent authorities of the contracting states shall act expeditiously in the process of the adoption, because this is children's time frame and not time frame of adults. And so I think we have to focus on the fact that there are still countries which are not party to the convention, or those that are just starting to become parties to the convention. That means that there are some countries with more experience, and the cooperation between these countries within international bodies can help these countries, because they're obviously in those countries that are mentioned that don't have the convention in place yet. There's more of a favourable environment for violations, and we have to really work on communication and cooperation.
Gracias, Antonio, for raising these challenges, and as well for giving us some ideas on how to address them. Another challenge in adoption that we have already touched upon a little bit in the first roundtable has been the financial aspects. And the past has taught us that money has had bad influence on adoption, which have led to illicit practices. And now I'd like to hear again from you, Marketa. How can we ensure that adoption is a purely child-focused protection measure where the money has no influence? What has been the experience of the Czech Republic in that respect? Thank you.
Yes, thank you. The Czech Central Authority, as the central authority of the state of origin, provides its service fully for free. The PAPs have to pay all necessary costs, of course, in their receiving state, but there are completely no fees for the Czech Central Authority, for the court proceedings in the Czech Republic, or, for instance, for the passport issuance. The prospective adoptive parents have to pay their costs of stay in the Czech Republic, for instance, traveling, accommodation, interpreter. The Czech Central Authority insists on the presence of an interpreter at the first meeting with the Central Authority because it is better to speak in the mother tongue of the prospective adoptive parents, even if they, for instance, speak English and we are able to communicate with them. This first meeting is mainly organized online, which also saves the costs. And it's usually approximately 2 weeks before the traveling of PAPs to the Czech Republic. Some prospective adoptive parents wish to donate some gifts to the children's homes where the child was placed. It is not recommended from our part. If they insist, they can provide it after adoption is completely finalized. The positive trend is that more and more children in the Czech Republic are not placed in institutions but in professional foster families who receive normal salary and social benefits for children, and there is no possibility to contribute them some money. The matching is decided by the advisory board of the Central Authority, which consists of independent experts. They are representatives of the ministry, of NGOs, of children's homes, of hospitals. There are of different professions. There are social workers, psychologists, pediatricians, representatives of foster families, and so on. The experts of the Czech Central Authority, lawyer and psychologists, prepare the proposal of usually 3 couples, and the advisory board chooses the best couple for each individual child. Not even the waiting time of prospective adoptive parents is relevant. It is always found the best family for the specific child, regardless the residence or nationality of the applicants or of their waiting time.
Thank you, Marketa, and it's really important to hear as well what you said in your intervention, that a country like the Czech Republic is offering inter-country adoption services for free. I think it does give us food for thought for the future. I'd like now to move to another part of this roundtable, more broadly about the future, and I'd like to hear several of you, because you come with different perspective and different backgrounds. So I'd like to start with you, Antonio. And what do you think authorities and bodies should improve for the future?
Well, so I think in addition to the actual text of the convention, it is necessary to highlight all the technical work that is generated, and the central authorities of the country, need to get to know each other and cooperate and work on those documents, the groups of experts, special commissions, good practice guides, toolkits, they all give us the way forward in terms of practice. And so I think that this has allowed us, to foster that cooperation, and it could be the best input that the convention's had to date. So inter-country adoption cannot be separated from the rest of any child's or any country's child's protection system. It really is important that this nexus is maintained. There's an enormous field of cooperation between authorities to share the advances in the entire ensemble of fundamental aspects, the prevention and early detection of abuse and neglect, the culture of good treatment, the avoidance of institutionalization, and the promotion of family care measures. These are all mutual knowledge and cooperation elements that can strengthen the exchange of information and adapt to the previous training of families and the post-adoptive accompaniment. And we really do have to prepare families and adapt this preparation for the real life situations of the profiles of the children waiting for adoption. We have to also, work on the post-adoptive side of things, and those the side of adoptees as and when they request this of us. And we have to find the right adoptive families for the actual existing profiles of the children that in real life situations are out there waiting for adoption, not some idealized scenario that the families might want in an ideal world. And so in receiving countries, it's the accredited organizations that must not limit themselves to being bodies that just deal with advancing formalities and official paperwork. They have to offer a support space to families where they, as they do in associations, can share their adoptive challenges in different stages of life, which is obviously a long process. And we know that if central authorities do manage to maintain a close relationship, without any shadow of a doubt, it's going to be really hard for the practices that overshadowed the pre-convention times to occur again.
Thank you, Antonio, for sharing your views from the perspective also of the central authority. And I'd like now to hear you, Charlotte, because you'll bring the perspective of the adoption accredited bodies. And how do you see the future of inter-country adoption, and what would you recommend for adoption accredited bodies?
First, both the Eurodoc and Nordic Adoption Council are fully aware that inter-country adoption being a very complex process, and each person or body involved in its process has its own challenges, even if it's an accredited body or a central authority. And we, of course, welcome independent investigation of the adoptions done in the past. So that's the past. And Eurodoc, the Nordic Adoption Council, believe that the convention is extremely important, as said before, and still needed. And it's very important that the accredited bodies follow and cooperate in accordance with the convention to continue to do so, and that the accredited bodies keep high ethical standards and continue to develop good practice in the line with the convention. We also believe that inter-country adoptions will continue to be needed as an important child protection measure for the children who cannot stay in the birth families. And as pointed out before by many, however, the children who are for inter-country adoptions today are, as said, often older children, sibling groups, and children with special needs. And we will also recommend that there should be more focus on the need and development of post-adoption services, and the balance of accredited bodies work is probably changing with greater activity moving from the mediating adoptions towards post-adoption services. And let's not foresee the strong relationships that accredited bodies have developed with their partners in the states of origin throughout time and the years. And this means that Eurodopt and Nordic Adoption Council together has big collective knowledge of the history, the culture, and the situation of the birth families from the state of origin. And this, in my opinion, working with post-adoption services is a very essential information when you work with post-adoption services, and the accredited bodies have a very important role in the future providing post-adoption services. However, of course, there is an issue around funding, and to some extent, fees paid by prospective adoptive parents to the accredited bodies have historically been drawn upon to fund post-adoption services today. But it is now becoming insufficient, unpredictable, and unsustainable. And in some state of parties fund accredited bodies to develop and provide post-adoption services, and both Nordic Adoption Council and Eurodopt would welcome this to become universal practice.
Thank you, Charlotte, for sharing with us the perspective of the adoption accredited bodies. I'd like to move to you, Benyam, because you'll bring, now we've heard the perspective of the central authorities of the adoption accredited bodies. Now you bring also the more international perspective. So from the perspective of the UN Committee of the Child, of which you are a member, what would you recommend for the future? And especially regarding the principle of subsidiarity, we've touched upon it today during this event. So what would you recommend from your perspective? Thank you.
Yeah, thank you very much. So from the recent, the more recent, the last 2, 3, or even 4 years, reports that we have seen, there are a number of cross-cutting themes that actually seem to emerge. For instance, there is a need to better understand the complexities and synergies that arise between inter-country adoption and international surrogacy, inter-country adoption and international kafala, and so forth, to make sure that our decisions are based on the best interest of the child. The sense of urgency is also much needed. We often increasingly find ourselves as a committee saying to states that please expedite the amendment to this law and to that law and so forth, because there is the sense of urgency, not just only for the purpose of the amendment of the laws and the introduction of new laws, but what they could actually mean for children, for instance, that are deprived of their family environments permanently, where inter-country adoption could be one option that could be considered for a family environment. We just finished our session last week, and a couple of weeks ago, we found ourselves having a conversation with a couple of countries that are predominantly Muslim countries that have entered a reservation to Article 21 of the Convention on the Rights of the Child, and saying to them, it's important that you actually withdraw these reservations. We understand that you apply kafala, you don't have adoption or inter-country adoption, but in the instances where you have a small group of individuals that do not necessarily subscribe to the Muslim religion, and adoption is open to them. We know of examples where custody placements and so forth are actually being used in fact, for the purpose of intercountry adoption. So we found ourselves engaging about the withdrawal of those reservations with those countries, and I think it's something that we see ourselves doing in moving forward. Now, best interest is, of course, easily thrown around, mentioned quite a lot. It's in the Hague Convention and a number of other instruments. But what it actually means, for instance, for children with disabilities, for older children, for children that are refugees and asylum seekers, mid-term, short-term, and long-term best interest, but also best interests, not just only for the decision at the adoption level, but also for pre-adoption, post-adoption services, and monitoring. What it actually means is something that should benefit from some reflection and guidance as far as I believe the Committee on the Rights of the Child is concerned. Now, I would be remiss if I don't mention this. Increasingly, we find ourselves engaging with states on the right to identity and the preservation of identity. It's becoming increasingly important. It has a cross-cutting implication for a number of provisions within the Convention on the Rights of the Child. For instance, we had, I recall, one country where the adoption of an act on the expansion of assistance for pregnant women and confidential birth arrangements. We spent a lot of time talking about it and its implications for the right to identity in the context of adoption. Another country where we were concerned about the lack of information on the elimination of the practice of secret adoption and so forth. So the right to identity, preservation of identity is going to be one issue that will continue to receive necessary attention. Now, in addition to that, getting the circle bigger, I do believe is important. What do I mean by that? More and more stakeholders are actually getting involved on the adoption, intercountry adoption conversation. For instance, increasingly, we see more and more stakeholders on the human rights field getting involved. We had a case a few years ago involving a human rights review tribunal that decided that a specific adoption act and Adult Adoption Information Act were being discriminatory. More and more, we're seeing national human rights institutions playing a very important role and important voice in the manner in which intercountry adoption is provided. Data remains to be one of the shortcomings. Sometimes it's unfortunate that we would have a conversation with a state that is very sophisticated, that has a huge machinery, but on some details pertaining to adoption, they can't come forward on that data issue. And the need to actually consolidate our data collection, which is disaggregated, remains to be a challenge that requires attention. Two final points. One is the politicization of the issue remains to be a barrier. You know, when countries are actually suspending intercountry adoption, when they're closing intercountry adoption, or the delay that it actually takes to get legislation to pass the final hurdle and so forth. We have heard countries, and I'm coming here on the subsidiary issue, we have heard countries that actually said, we're closing intercountry adoption once and for all, because that will also help us to redirect energy, effort, and awareness raising and training to make sure that domestic adoption is prioritized, that deprivation of children from a family environment, the prevention measures that we can do to that can actually be consolidated. But in reality, those promises remain to be promises. And when one wants to address and reduce or do away with the need for intercountry adoption, the subsidiarity principle needs to be a very central and critical element of that conversation. And states are required to undertake legislative, administrative, and other measures to make sure that the end result is not just only to do away with intercountry adoption. The end result should actually be to provide children a suitable family environment. So from that point of view, politicization remains to be a significant challenge that I believe should be addressed. And my final point is the following. When the optional protocol on a communications procedure to the Convention on the Rights of the Child was introduced, some of us had hoped that a good number of the cases pertaining to The Hague might actually be on intercountry adoption. As it happens, currently, a good number of the cases are not on adoption. They're actually on parental-child abduction. But we do believe that there will probably be more cases involving on financial gain, involving on identity and so forth, that will help us to clarify the obligations and the various measures that states need to undertake. Over to you.
Thank you, Benyang, for all this recommendation. It's thank you as well for what you said about the importance of the principle of subsidiarity, and when you raised this this point about not so long ago that you suggested to a state to take to withdraw their reservation. So thank you for all your points. Thank you to all of you for sharing your perspective. Also, one thing of the future of intercountry adoption, and that some of you have already touched upon, the future of intercountry adoption is also very much linked to the post-adoption services and the search for origins that adoptees are undertaking. And I'd like to go back to you, Marketa. From your experience working as a central authority, what would you recommend in that regard? Thank you.
In my opinion, there are two important points. The need of adoptees to know their identity, it's clear, but also the protection of personal data of them and also personal data of birth families. The maximum of information on origin of the child while keeping the anonymity of parties is provided to PABs during the matching process, at least in the Czech Republic. Later, if the adoptees wish to know more about his or her origin, it cannot be expected that the adoptee can receive detailed updated information without involvement of the birth family. The activity from adoptee and or adoptive family is necessary if they wish to get some updated information on biological family. They must be ready to share some information about their own life. If the adoptive family sends some information and photos to the biological mother, according to our opinion, all the mothers are ready to answer. During this process, the anonymity of both parties must be strictly kept. The problem is increasing number of these cases of searching of origins. There usually are not sufficient personal and financial resources at the central authority or accredited bodies. It was here already mentioned. There is not only providing of information, but adoptees and biological families need personal assistance of an expert, especially during the first personal meeting, if they wish to arrange it. Unfortunately, the support from the public authorities is available not even on domestic adoption cases, and the assistance provided by the Czech Central Authority is mainly exceptional. But we are trying to do our best and to help our adoptees if they wish to get some information, but really our resources are limited.
Thank you, Marketa, and I like what you started with recalling the right of adoptees to know their origins. I'd like now to move to you, Bernadette. I have a question for you. Thanks to your experience, how do you ensure that all the documents that are drafted during the adoption process, how do you ensure that all these documents, they are drafted seeking that the adoptee may read them in the future? And what would you recommend in that regard? Thank you.
Okay, thank you. Of course, on the premise that we will not lose sight of the fact that intercountry adoption is a solution for children who have no permanent families, okay, and not for parents needing to adopt, okay. On that premise and being child-focused, the documents currently, child study reports, social case study reports, there is no guideline, no current guideline on what should be included in the reports. It can vary. Since there is no template, and also we have to keep in mind that the final reader and the most important audience reader for this document is the child itself in the future. So that being said, we have to ask, what information should be included in the child study reports? We go to, as Benya mentioned earlier, identity. So all the clues should be there to enable this child to find their roots later on. But as it currently stands, there some information in the reports may be unverified, or verified. It can be merely the opinion of the writer. It can be over-dramatized data, or it can even be simply a translation failure. So maybe the recommendation is, in order to prevent any mental or psychological damage to the child or adult who will read the document, maybe we should start a conversation on what really has to be specifically in this child's documents. Maybe we limit, maybe we see what is necessary. I think Charlotte would have a lot of ideas to share regarding that. Thank you.
Thank you, Bernadette, and you're you're absolutely right. It's a nice way for you to finish, because my next question was actually to Charlotte, because you, Charlotte, in your daily work, you actually assist adoptees with the search for origins. So, what would you recommend other authorities and bodies to do with regard to search for origins? Thank you.
I would like to thank Bernadette, because yes, I do have a lot of thoughts and ideas, but that's not the question. First of all, I believe that as I said before, it's important to recognize the lifetime perspective of the adoption. It's not only for the adoptees. Let's also remember the children of the adoptees and maybe their grandchildren, and throughout the generations. And the need and perception for post-adoption services is also wider than the search of origins, and let's keep that in mind. I wrote some examples here. For example, postpone preschool could be one of them. Focus on attachment with the adoptive family. Also, motherland guidelines guiding through motherland journeys. Actually addressing racism for some families, and also forming the identity not only through the background information but in the society, and also of course mental illness. So services throughout all of these examples, and it must be lifelong, dynamic, individual, and also of course easy to access, because even if it exists, it might be a challenge to reach out to the adoptees, especially the teenagers, in my experience. And where I work, we are actually 3 adoptees that work with the post-adoption services, and we are also involved in the searches when the search is initiated by the birth family, not only the adoptee. And we also have the preparatory workshops and lectures regarding several subjects. We organize motherland tours in groups and also individually. We support a big number of adoptees who cannot search for the birth families, maybe because their background is unknown. We also recognize the importance for adoptees to have access to their biological and cultural origin, not only the biological, but also the cultural. And it's important for adoptees to get a positive impression of the perception of the state of origin. I know a lot of adoptees are affected by how media talk about the country or the state of origin, for example, China, for example. And in post-adoption services, it's important to make a distinction between the reason for the separation of the birth family, even if there's a consent to the adoption. The reason is different, and the event of than the event of the adoption. And central authorities have a role, an important role in supporting the development of post-adoption services, not only for the adoptees and the adoptive parents, but also the birth families, as you, Bernadette, some of you mentioned. We cannot forget the birth families, and post-adoption services from the moment of the consent to the adoption and throughout the birth family's different stages in life. And a good post-adoption services provided to the birth family could maybe actually lay a stable foundation for the successful reunion maybe later in life. And this is, of course, essential for both the adoptee and the birth family. And we also, of course, welcome more research regarding the birth family in the state of origin to better inform this field of practice in the future.
Thank you so much, Charlotte, for sharing all the important work that you do, and also for recalling that yes, post-adoption services is for adoptees, adoptive families, but also the birth families. I think you made so many relevant points in your intervention. Thank you so much to all of you. I have one final question to all of you that we've been asking all the panelists. So in one sentence, if you could briefly let us know if you had one wish, one desire, one recommendation for the future regarding inter-country adoption, what would it be? And I'll start with you again, Charlotte.
Okay, so inter-country adoptions should once again be recognized as a legitimate child protection measure for children who cannot stay with the family in the country of origin.
Thank you, Charlotte. Bernadette?
Okay, yes. Considering that the profile of children are going towards the older children, and special needs children and sibling groups, hence the higher risk of disruptions in displacements. Maybe some kind of uniform protocol or approach on how to handle the disrupted placements. So it varies from country to country as it is. Maybe if we can come up with something common, then it would be so much easier and the children will be protected in the process. Thank you.
Thank you, Bernadette. Antonio?
Well, I would propose a short-term wish, and a cheap one at that. It wouldn't be very costly. We have to optimize the advantages that the Convention of The Hague offers us in order to strengthen cooperation between states and between the different systems of protection. It can't be that a biological mother finds herself in that situation like the Colombian lady being forced basically to put her child up for adoption. I mean, we talk about adoption, temporary care, fostering, etc. We all have different experiences and we've got a lot to share between us. Claudia was talking about her experience and the Romanian authorities who provided her with the resources in order to find her a biological family. That was very important. There are so many improvements that we can institute in order for our practices to improve.
Antonio, and now Marketa.
I would like to share two ideas. Firstly, in ideal world, there is no need for adoptions at all, and all children can live in the environment of their birth families. And secondly, unfortunately, we do not live in an ideal world. And I believe that all persons involved in adoptions shall accept the principle that adoption is a service for the child, for the specific child, and everything shall be done in his or her best interest.
Thank you, Marketa. And the last word for you, Benyam.
Thank you very much. I was here during the 20th year anniversary 10 years ago. It's amazing how the time flies. And I have the same view that I had then, and I would basically say establishing safeguards to ensure that the best interest of the child is protected in inter-country adoption, and establishing a system of cooperation and ensuring recognition has to be low on emotions, low on anecdotes, and low on politics. And it has to be high on evidence, has to be data-driven, and it has to be child-centered.
Thank you, Benyan, and thank you to all of you for sharing your expertise, for being here. We've heard a lot of practices, a lot of good practices. Also, we heard challenges. We also heard that the landscape of inter-country adoption is constantly changing, and it will continue to change. And that we will need to continue adapt our practices to all these changes. We've also heard again the importance of the post-adoption services, and that post-adoption services, they are as important as the adoption process itself, and that we really must ensure that the adoptees, their families, they can really receive all the appropriate support that they need throughout their life. So thank you very much again, and I will now pass the floor to Ms. Karine Rosalia for the next part of our event. Thank you.
Hello, everybody, and thank you for the very interesting perspectives that were shared today, especially to the panelists who shared their very personal life stories and help us understand how intercountry adoption and, by extension, the convention has real impact on people. On the occasion of this anniversary, we also have the pleasure of celebrating the publication of the toolkit on preventing and addressing illicit practices in intercountry adoption, a resource that seeks to address the problems that we've discussed earlier in today and form the best foundation for the future of intercountry adoption. With appreciation to the Central Authority of Australia for bringing the topic of illicit practices at the forefront of discussions, a working group of states and observers was created with the mandate of considering the development of more effective and practical forms of cooperation between states to prevent and address specific instances of abuse. That was their mandate, and the working group went to work for 6 years, no less, discussing the practices they had seen and discussing what solutions had worked for them so that there could be some cooperation towards some standards to that effect and what they hoped for the future. As a result, the group produced 4 practical tools that address how to put cooperation in practice, from things like sharing information to more novel points, for example, temporary measures to protect a child during the time of an investigation, or encouraging the development of services for impacted persons, such as counseling, which we've heard a lot about today, and compiling resources on legal assistance, to just name a few examples. So these 4 tools are combined in a toolkit that is now available on the website of the Hague Conference on Private International Law. You're seeing on the screen the new cover for it. Very exciting. It's in English and French, and will be followed by Spanish at a later date, and possibly some other languages as it grows. So to give you a little taste, we're going to navigate quickly through it to give you some reasons to go and look at it for yourselves and really immerse yourselves. But the first part, as you can see, is composed of fact sheets that cover 11 topics that range from misrepresentation of identity, for example, to the preservation of records. And then if we can switch the page to give you a sample. Each fact sheet identifies what constitutes an illicit practice or an enabling factor and provides how to prevent the problems. So we're seeing right now on the screen some examples of illicit practices, and in green some ways forward. And then if we can switch turn the page, and here is an example of enabling practices, and again some ways to address them in green. So next, please, comes a checklist for central authorities and accrediting bodies. That's a very practical tool that authorities and bodies can use to review each case like this, to screen out any issue and provide guidance on what to do when information is incomplete or issues are revealing that specific stage of the process. So that's a very practical tool that we hope will be in use also. Next page, please, is a model procedure on how to respond this time to suspected and actual cases of illicit practices. Next. So it focuses on measures to take from the time the suspicion arises to after the investigation is completed and what the repercussions might be for each of the different parties that may be impacted or involved. And next, finally, we have some guidelines on cooperation and coordination. That's, again, a word that we've used a lot today. And of course, it's in the title of the convention itself. And that tool, if we can go to the next slide, helps states coordinate their efforts to prevent and respond to patterns of illicit practices. And here's on your screen just one little sample. Thank you. So that I hope will give you a little sampling and desire to go and explore it for yourselves. So I want to spend a few minutes talking about those who were involved in this project and really the convention, of holding the convention. But thank you to those who participated in the drafting of the toolkit. There were 29 states of origin and receiving states, and observers. We had UNICEF, Intercountry Adoptee Voices, ICAV, International Social Services, ISS, and Nordic Adoption Council, NAC, who contributed their times and shared invaluable input based on their work and lived experiences. And I want to take this opportunity to highlight the hard work of Marie Riendeau, who was dedicated to making this toolkit a useful resource to end illicit practices. You saw the checklist that was an initiative of Canada, and they put tremendous work in making it, bringing it to completion. As Marie gets ready to enjoy a well-deserved retirement, I want to salute her. Merci, Marie. Thank her for her immense expertise in private international law and experience in intercountry adoption that she has shared with the Hague Conference and with the world. The toolkit and all the day-to-day work of the convention, of course, is not possible without the wonderful Laura Martinez Mora and Capucine Page, your powerhouse team that ensure that states have what they need to implement the convention with the best interests of children at heart. Thank you to Lydie Delouf and the team of translators for how quickly you've worked on translating this tool that we hope will be in use widely, and for your attention to detail. And on that note, thank you to the Permanent Bureau and the Secretary General for your work preserving the legacy of the convention. And I would be remiss not to recall all the work of former Secretary General Van Loon and Secretary Jenny Degeling for bringing the convention alive. And you were not alone, of course. Many were responsible for hard negotiation, and this is the tool that we have, and by extension, the toolkit to reinforce it. We talked a lot about the bridge from the past to the future today. And that brings me, that has a lot to do with the people. The people are that bridge. And so that's why I'm so encouraged to have heard so many hopeful inputs and to witness this level of dedication of professionals and people who have the lived experiences and are willing to share how to inform good practices and make sure that the children of tomorrow can ensure a safe process. I have a lot of hope for intercountry adoption in decades to come, and thank you to all who have paved the way. Thank you. Over.
Thank you very much, Karine, and thank you to you, Karine, because you were the chair of the working group on preventing and addressing illicit practices, and without your leadership, it would not have been possible to have this toolkit. We fully agree with you with all the different acknowledgements that you had put of people who were before us in the working group. There has been many people involved in this work.
So a big thank you to all of our panelists for having shared with us their points of view and opinion on such a very important subject, and one which, of course, we have varying points of view on. perhaps. We can say that there are certain things that everyone or almost everyone would be in agreement with saying after 30 years of the running, or since this convention's been up and running. And I think that we are all in agreement that the best interests of the child should always be at the centre of our preoccupations when we speak about adoption, inter-country adoption, and the systems behind it in general. And I think that everyone here is in agreement that growing up in and living within a family environment is obviously essential for every single person's harmonious and complete development. And that's true of everyone. And so it's true that we've also spoken a lot about cooperation. It's in the title of our convention, and we want to talk about fighting against illicit forms of inter-country adoption, and we want to really make sure that we work on all the different regimes and dialogues between states, within states themselves and between states within their different authorities is essential so that we're able to maintain the work that we do and upkeep it. And I think it's really important that our protection systems are well founded so that they can have the material and human resources needed so as to be able to put these things in practice and best protect children. Today, we've heard about different experiences related to adoption, but we recognise that there are a lot of other experiences out there, so many other different lived experiences and different life experiences. We've only heard some of them, and we're very conscious of the fact that there are so many others out there. Perhaps for our 40th anniversary, we can hear from adoptees that were adopted under the Hague Convention. We're all really interested already to hear about what they think of it.
From what we heard today, I think that many agree that the success of the 93 Convention is linked to its proper implementation in its 105 states, which are party to this instrument today. We have now many tools, we have procedures, we have guarantees. Yes, there has been many changes, there has been many improvements, but we can still do even better. Therefore, it has been said, if there is a need for an inter-country adoption, for example, for special needs children, we should have the instruments to do it in an ethical and legal way. We know how to do it now. There should be no reasons to have illicit practices. They may still happen, but we should do our utmost that it is not. For example, we hope that the toolkit that will be available as of tomorrow in our website in English and French can provide some guidance to authorities, bodies, organizations, and anybody who is interested in inter-country adoption to identify and prevent illicit practices on the first coming, and if regrettably they occur, then how to address them. Therefore, we do have tools. Not only the convention is the basis and it's extremely important and can really bring a change, but we also have other tools to reduce this risk. However, as we have been recalled as well in the first roundtable, there are also questions that we need to still work on. For example, the challenge in this child protection measure is money. We know it, and therefore we have to continue, as the convention says, to really say no to improper financial and other gain.
Today's panelists have also spoken to us about the importance of post-adoption and the search for origins. And as our Secretary General reminded us in his introduction, there's at least 1 million people who have been through inter-country adoptions. And so we know that this post-adoption issue is really fundamental and should be the heart of many states' works. There are some states that have been developing best practices and good practices, and there are some that even today don't know where to go nor which door to knock at. And so I think that, if I'm allowed to say so, there's a lot more that we can do to improve what we've got right now. And I think it's important that we continue to cooperate with one another. And as of our stance from the Hague Conference, we want to give you that platform. We want that cooperation to take place internally and internationally. And I think so as to finish up, I just wanted to leave you with some of the words of the biological mother that we heard from earlier, Janet. We would have liked to have explained absolutely everything that we had to discuss. We had a lot more that we wanted to discuss, but Janet said to us as her final wish, she would like to have seen, at least in her case, that knowing about the origins for her daughter, knowing about the origins have been her means to reach resilience for her own life. We hope that we're able to continue to be able to guarantee that right to an identity that people have. And we know that when we go through the process of adoption, it can be done legally in accordance with the law and ethically, and it can be done with all of the support and advice that we have here to offer. I'm going to finish up on this note. Thank you so much for your interest, for having been here with us this morning, afternoon, evening. In fact, in some countries, it really has been a real pleasure for us all, Capucine, myself, and everyone else that's involved behind the scenes that you're not perhaps seeing, but that have helped in the organization of this event. This has been a really good opportunity for us to be in contact with a lot of you, and I think that there's been a lot of people who have helped both Capucine and myself so as to be able to organize this event, not just internally, but internationally speaking as well. Thank you so much for everything, and we'll continue to cooperate and work together in the future. Thank you.
Thank you.